Welcome back. Welcome back, everyone. Hope everyone enjoyed their lunch.
Thank you, Selectmen.
Thank you, Selectmen. Mom always liked you best. All right, so moving on to Article 10. To see if the town will vote to raise and appropriate or transfer from available funds a sum of money, and if so, what sum, to be used pursuant to Chapter 114, Section 15 of the general laws for the improvement or embellishment of the cemeteries throughout the town, the care, preservation, or embellishment of any lot or its appurtenances therein, or take any other action related thereto. Do we have any comment? I guess we don't probably. That is the Board of Selectmen for the Cemetery Commission. I thought I saw Chucky earlier. I don't know if she wants to speak for that in any way. If not, I'll open the floor to comment. Okay, any comment up here? Do you have comment, Paul?
This is a standard article
Yes.
that we do every year.
Yeah.
I believe the selectmen supported it.
Yes, we did support it.
Okay. Any comment or?
Is there any money attached to it?
You'd have to ask the town accountant over there.
24,000.
Did you hear that? 24,000. Any comment up here? Any further?
And where does the 24,000 come from? Let Carol chew first.
Sorry, Carol Marple. I just would encourage somebody to clarify that I believe that's already their money, but it just
Yes.
has to be voted.
Yes, that they can use it.
Yeah.
Okay. No further comment. All right, then I will take a motion to recommend favorable action on Article 10.
I motion.
Second? All in favor? 8-0 of all those present, unanimous of all those present. Okay. The following three articles relate to changes being made to town personnel policies. First one, Article 11, to see if the town will vote to amend Chapter 3, Powers and Duties of Town Officers, not prescribed by statute of the general bylaws, by adding a new Section 13 as follows. Section 13, the Board of Selectmen is authorized to enter into contracts on behalf of the town for the exercise of the town's corporate powers for all matters within the jurisdiction of the Board of Selectmen on such terms and conditions as it deems in the best interests of the town, but subject to any terms and conditions as may be imposed by town meeting. The Board of Selectmen shall not contract for any purpose or any terms or conditions inconsistent with the provisions of any general or special law, or take any action, or take any other action related thereto. So, is there someone who wishes to speak as a proponent of this article?
Yeah, I can
Okay,
explain.
great.
Basically, the town has been talking with the police department and breaking out a lieutenant position. I think it was 2 years ago, the Board of Selectmen, on behalf of the town, entered into a contract with the union to split one of those positions out to become a new lieutenant position. And I believe PD lost an admin position at the time to make that work out. At last year's town meeting, the article that was brought forward was to create the lieutenant position, and at that time they thought that that would allow them to be able to, the town to enter into contract with this individual. In fact, what it did is create the position as part of the personnel admin plan as an exempt position that cannot earn overtime. And part of the agreement with the individual was he was coming out of a union, he would still continue to earn overtime. So these three articles basically accomplished what was intended last year. And what they do is it amends the personnel admin plan to exempt this one position from certain sections of the rest of the personnel admin plan to allow him to get overtime under the contract. It also
Or
author-
anyone who would fill that position.
Right. And it authorizes the Board of Selectmen to enter into a non-department head position, an employment agreement with a non-department head position. Under state law, they can enter into a contract with me, police chief, fire chief, CM&D director, but the state law doesn't provide to enter into a contract at a lower. So it authorizes them to do this. And then the third one is the approval of the employment agreement, which is the lieutenant's employment agreement. And once all of these, if they pass at town meeting, then the selectmen can hold a meeting and vote to sign that employment agreement.
Okay, I have a question then. I apparently have, and I want to make sure that I do this correctly procedure-wise, but I had been under the impression that if Article 11 and 12 pass, that the Article 13 is unnecessary. Is that correct? Okay, so I just, that didn't quite match what I thought I just heard, so I just wanted to make that clear to myself. Any comment from, yeah, Chuck? Sure.
It's just a quick drafting question on Article 11, the very end, the contract can't have any T's or terms or conditions inconsistent with provisions of any general or special law. Do you also want to include in that or regulation or town bylaw? Because I'm assuming if there's a Fair Labor Standards Act reg, I mean, obviously, just for drafting purposes, I think it's, I would insert special law or regulation or town bylaw.
You're saying that that would give the selectmen the authority to exempt it from other things outside of the personnel admin plan?
Yeah, and just that any
Yeah.
contract is going to be consistent with state and federal laws, regulations, or town bylaws. So if there's a specific town bylaw that's been adopted at town meeting, the Board of Selectmen would not be authorized to override that town bylaw in the contract.
That only works if Article 12 is adopted. Because otherwise... So, I'd make a couple of comments. First of all, these are grouped articles, even though they're separately numbered. 11 and 12 are kind of together. And Article 12 changes the personnel administration plan, which is referred to in the personnel bylaw. And if you had a provision that said you can't have a contract that's different from a regulation, that means we couldn't have a bylaw different from the personnel administration plan, because that's part of the personnel bylaw. We get stuck in a trap. You'd have to have Article 12 passed in order for this amendment that's proposed to work for Article 11.
Okay.
I think Article 12 has to pass either way. We can't do this without Article 12 passing. We could do 12 and 11, or we could do 12 and 13.
Okay, and so my next question is, are Article 11 and Article 12 actually in the wrong order here? Would we,
With that amendment.
If that amendment, if you made that amendment, yes. If you
but
don't
make
the
that
amendment,
amendment? No. Okay. And do you have a,
How would we make the amendment?
do you have the feeling, any feelings about the amendment?
don't think it's necessary. We're obviously bound to not disobey any laws. We have taken oath of office. This doesn't. I just don't see it's necessary. It's not that it's not that I oppose it. It just adds complication.
I can see the reason why the town would not want to give the Board of Selectmen apparent authority to override local bylaws. So to that extent, I think it makes some sense to have Chuck's amendment, but I agree with Paul, I don't think as an absolute matter it's necessary because we're still bound by law.
Yeah, in fact, I think the whole inconsistent clause is unnecessary. You can't enter into a contract that's contrary to law, but if you're going to list it, I think it should be a complete listing.
So you said take the whole sentence out.
So, all right, well, Grace,
I'm not a lawyer, and the only thing that struck me about this is that it was very broad when you had a very specific and more narrow reason for it. And I was applauding Chuck's language because it reflected my sense that it needed to be clear, not because this board would ever do anything, but because the town bylaws should be written for great clarity and limits where wanted. If indeed Chuck thinks that none of it, could you explain why? Do you think none of that?
They don't have the authority to enter into a contract that's illegal, but if you're going to have language saying that we can't enter into a contract that's inconsistent with X, Y, and Z, X, Y, and Z should be a complete listing, so it can include state and federal regulations and town bylaws. In my opinion, that's a complete listing.
Okay. And how expansive is the article in terms of its granting power?
excuse me,
for
Grace,
contract?
could you just see if that mic is on?
I don't know how.
It is.
Okay, it would help if I spoke
All right,
into
I was
it.
getting a message that people should use the microphone and introduce themselves.
Chuck?
No, it's on. They said.
Oh, okay. Okay.
Sorry. I guess my question is this. I totally support you having the power to do what you need to for the lieutenant's position. I just want, if there is an attempt here to expand powers far beyond that, it should be discussed in that way. And I don't understand the language well enough to know whether that is a possibility.
Well, if I could,
Mike's on.
if I could kind of, I don't know if this is on.
There it is.
I think town council wanted a broad article here rather than a specific article about Bento's contract because of the way this thing arose. It's taken us almost 3 years, 2 years to get a contract for this individual because of all these restrictions. And we don't know if there'll be another change in the police department or the fire department or some other department for which we want to be able to do a contract for an employee. So rather than every time having to go to town meeting with 3 articles and all of this complication, her thought, as I understood it, was for once and for all, give us the authority to set this thing up for not just this situation, but set us up so that we can address these issues for another employee, perhaps in another department as it might have come up.
Right. I actually would, at some point I was going to make this statement, so this seems like an appropriate time to make it, that in general, I don't look favorably on writing laws for particular situations. I think it's sort of bad business. And so if this article provides a broader framework for the town to go forward and covers a variety of situations that might come up, I am personally, sort of more inclined to support it.
That was the intent.
Can I ask a question? I'm a little confused, though. Article 11 gives you the powers to enter into contracts. Doesn't the Board of Selectmen enter into contracts of all sorts now on behalf of the town? Am I wrong?
You're correct.
I am correct that I'm wrong?
No, chapter 40, section, I think it is 3 or 4, allows us to enter into contracts.
Well, Article 11 says it's authorizing you to enter into contracts on behalf of the town for the exercise of corporate powers within the jurisdiction of the board. So if you already have that power, I'm not sure. I'm reading something wrong, because this seems to say you have the authority to do your job.
As far as I know, there's something in state statute that prohibits them from entering into contracts, personnel contracts, with individuals below a non.
Fair enough. Then, getting back to Grace's point, if what you're trying to remedy is, as Paul says, the ability to enter into personnel contracts, why doesn't Article 11 refer to the authority to enter into personnel contracts, as opposed to all kinds of contracts which you already have the authority to enter into?
That's a question for council. The one thing we specified for council is we wanted to solve the bento problem. And we didn't want to have to come back next year and say, whoops, we forgot yet another thing. This is our second or third time to try to nail this contract down. So I think with that specification, to do whatever had to be done, they were trying to cover all the bases. And I want to reiterate what the town administrator said, that state law specifically authorizes us to enter into multi-year contracts with specific named positions. That's the police chief, the town administrator, fire chief. There is no provision in state law to allow us to enter into contracts with other people. And there may be other deputies or lieutenants or other near top management that we wanted to set the stage so that we could do if necessary. And that's what this was all about. And council said that was the language that we needed in Article 11 to do that.
Yeah, the other way I look at it, not being a lawyer, but from a practical perspective, Lieutenant Bento has been very patient on this whole process because we've run into some roadblocks in executing a contract with him. But to the extent we do 11 and 12, or 12 and 11, where 11's amended along the lines Chuck's doing, that would certainly, from my perspective, be preferable than Article 13 as a fallback position, because that's unique to the individual, and you're asking voters to approve an agreement that they'll have, that's a difficult thing for people to read an agreement. It's an agreement that we all have voted in support of.
Right. I mean, I prefer personally to address the general rather than the specific case, but.
Mary, I never meant to narrow it so much as to be to the specific case, and I very much think that Jeff's suggestion, it's personnel contracts where you are limited by law, and therefore that's the solution to unlimit you in regard to personnel contracts. And unless someone can explain a good reason why it should be more broader than that, I would respectfully say that I would support adding the word personnel.
You taking out that last sentence?
That I don't understand, and I leave it up to Chuck.
No, I would just say that I agree with Jeff. The first time I read this article, I think this is trying to state explicitly what is already the implicit power of the Board of Selectmen. They've got to have the power to enter into these contracts to do their work. But if it's intended to deal with the state law dealing with personnel contracts, I think Jeff's right. That's what it should be limited to.
So
And take out the last sentence. So you're
Vicky
saying
has a question?
take out the last sentence?
Yeah, I don't think it's personally necessary.
If you put personnel
They don't-
contract in there versus the last sentence?
Yeah, they don't have the authority to enter into contracts that are illegal and have no intent of doing it. So
It's redundant.
in the same way, it's the same point Jeff was making. Use the microphone. It's the same point that Jeff was making, which is it's simply stating explicitly what is the existing
Right,
law.
Right, okay.
So is the way to proceed on this to ask the Board of Selectmen to re-vote their article?
Well,
11 to include personnel and make that decision first and then turn that over to us?
I guess from my perspective, I don't know that I'd necessarily be comfortable doing that. We've already been provided town council's best wording here, and that's what I'm comfortable with. Now you're asking me, I mean, there are plenty of attorneys in this room, and I respect all of their perspectives.
And I'm
that they're
not one of
applying to this. I'm not one of them, but even when other attorneys speak, on town matters, I typically rely on the town council's approach, and that's what you're seeing here. Unfortunately, town council's not here today. I know that Rick has worked with town council. He may have some additional perspective to add to this. All we're trying to do is get the deal done with David.
Yeah, and I'll just add that I feel strongly that town council's opinion on these articles is right on. I agree with Peter that I don't think it would be a great idea for the town to go against town council's opinion.
Any other comment from the floor? Okay, I'll bring the discussion up here to advisory.
Just a point of clarification. Is this to be able to pay overtime, right? Is that correct? Because under his union contract, he was getting overtime?
It's to address several things.
But is this one of them?
That's one of them.
And do lieutenants normally get overtime?
Yes.
So why isn't that the existing condition to begin with?
Well, because his position has been removed from the union, so he no longer has union protection. So he's kind of out in the lurch, so to speak, on his own. So the idea was to develop a contract for him to protect him.
Even though lieutenants normally get overtime?
Correct.
But still within the protection of unions. Right? Is that fair?
Correct.
Well, the issue, as I understand it, is simply that our town's personnel plan does not allow him to get it. That's why they want to make that change. So it's, yeah, lieutenants may generally get it, but what we're hearing is that our particular personnel plan precludes it, and they're saying they want to change our town's personnel plan to allow for him to get what apparently is typical of lieutenants generally. Is that correct?
The personnel plan plus Mass General Law.
Fair enough. Fair enough.
The position that was created last year was an exempt from Fair Labor Standards Act, and our personnel admin plan specifically prohibits an exempt position from earning any overtime.
Any other comment up here? Any other further comment from the floor? So this is Article 11, and I will take a motion to recommend favorable action on this. So if I can have the motion first? Okay, no one wants to make that motion?
I'm actually still confused here. believe it
Well,
or not.
we can make the motion, we can have a second, and then we can discuss. So, is anyone willing to make the motion? All right, I will make the motion. To recommend favorable action, to move this along, to recommend favorable action on Article 11. Is there a second? Sure. Okay. Open it up for discussion then.
Can I make a suggestion? I think the wording issue is a question for you to do in your motions. When you actually do the motion, you can address with town council.
You're talking about motion at town meeting.
Motion at town meeting. That you can deal with the details there. I think at this point, what you've traditionally done is deal with the sort of bigger global issue. And the issue for you here is, are you willing for us to do a contract with Bento? That's really what this is all about. If you are, town council says we need favorable action on this article and the next article, or 13. When you get to doing the motion for the floor of town meeting, then I think you'd have town council working with you on those motions. And that's the point where you should ask, can we change a word here, can we change a word there, can we put something in, take something out?
I think that's one excellent suggestion. The other excellent suggestion is for us to approve this or recommend in favor of this with the word personnel included. And if at the time of town meeting, town council explains to us why removing that word effectuates your purpose, then we can make the motion that way then. Because it's not just wording. This is a key question. Does this relate to your ability to handle the issue in front of you, which is a personnel matter, as opposed to something way beyond that? So from my perspective, what we're looking at is a substantive question, not a technical question. You're saying you need the power to enter into personnel agreements, notwithstanding state law and our own town personnel plan, and we're saying we buy that concept, and that's what we're willing to approve. If you need to go beyond that, at least I, for one, would just want to understand why you have to go beyond that.
George?
It's my understanding that there
Could you identify yourself?
Oh, I'm sorry. George Shea, 19 Deerfield Road. It's my understanding that there are certain contracts entered into by departments within
the town that require signatures of the department head, especially if it's an elected department head. I'm wondering what the impact of 11 would be on that operation of the law, which requires, let's say, the clerk to sign a contract, or the tax collector to sign a contract, or the assessors to sign a contract.
You're asking me? I am not a lawyer.
But I'd ask the
TV.
chair to ask the Board of Selectmen what their intent was.
Well, I can tell you what the article says, and it says, "For all matters within the jurisdiction of the Board of Selectmen," is in the language of the article. So it would not cover matters that are not within the jurisdiction of the Board of Selectmen.
That invites a lawsuit, as far as I'm concerned. It would seem to me that if the Board of Selectmen is moving to get that authority, he already has that authority, if it's within the jurisdiction of the Board of Selectmen. If he doesn't have that authority within the jurisdiction of the Board of Selectmen, then I think that the chair should ask the board to enumerate those contracts which they are not able to sign currently and would be able to sign if this passed.
Gentlemen?
George, are you thinking personnel contracts?
No.
Or
No.
just other contracts that other
As I read
department
11,
heads
it
need to
doesn't
sign?
limit it to personnel.
Okay, so that's your concern, is that it's
Yes.
other...
Yes.
You're concerned that the word personnel is not in there?
No,
Is that
12
correct?
takes care of personnel, it seems to me.
Okay.
The only contract I'm aware of that a department head could, or an elected official could enter into without some sort of authorization is town accountant under state statutes allowed to enter into contract for the, I think it's the audit, right? Yeah. But I'm not aware of any other situations that, because they would fall under procurement unless there's authority granted under statute.
I believe that the town collector or tax collector, depending on what happens at the town meeting, has specific authority to sign certain contracts which the Board of Selectmen do not.
Aside from the fact that town council drafted this, does the Board of Selectmen object to the word personnel being put in there to...
No, and I think Jeff had a suggestion that makes common sense to me as opposed to, as well as legal sense. So, and to the extent that it needs to be altered because council says, no, that, defeats the purpose here, then we'll deal
Worry
with
about
that.
it then.
So what are you saying to put personnel in and take that last sentence out? Is that what you were saying, Jeff?
I don't, if you're asking me?
Yeah.
I don't think that last sentence coming in or out makes any difference. I just leave it
Are you
alone.
putting personnel in front of the word, so on the
Contract.
first line,
Yes.
into personnel contract?
Yes.
Yeah. So I'd move to amend the motion to insert the word personnel in front of the word contract.
Do we have a second for that motion? All in favor of that motion? Okay. So
Madam Chair?
now,
Question.
I don't think my question has been answered.
okay, which is, I'm sorry, George, really.
Okay. My question was, is this Article 11, before it was amended, does it address, or would the selectmen ask the town council to address, or the selectmen address, the contracts that they cannot sign now, that they will be able to sign as a result of this, if it passes?
Okay, so without, he is asking, without the addition of the word personnel, what can you not do now that you could do?
I can't answer that. It's my understanding, all this is, it doesn't allow us to do anything more than we currently can do, except allows us to do what we're trying to do with lieutenant position.
Okay, and now we've specifically taken care of the personnel
Personnel issue.
aspect.
Well,
But
then
you
I'd
still-
ask
We
what
will,
the difference is.
we will consult with town council to further answer that question. We can't, I can't answer it today.
Well, then I'd ask the committee to take a vote of no action on this article until you have sufficient information to determine the impact of this article on the operation of the town. And I don't understand what the difference is between Article 11 and Article 12.
Well, I'm not a lawyer. Article 11 speaks to all personnel, and Article 12 speaks to just adding I believe anyway, that it adds the police department superior officer particularly to other positions that they can enter into
If
contracts with.
all Article 11 is intended to do is to address the personnel issues, then I think that the article should be amended in such a way that it's clear that that's what's limited to.
That's
If
that's
it-
the motion that's on the table
I'm
now.
not sure that motion indicates that. Does it say included?
You gotta take that
I'm going to revote,
Would you read it as amended, please?
The Board of Selectmen is authorized to enter into personnel contracts on behalf of the town for the exercise of the town's corporate powers for all matters within the jurisdiction of the Board of Selectmen on such terms and conditions as it deems in the best interest of the town, but subject to any terms and conditions as may be imposed by town meeting. The Board of Selectmen shall not contract for any purpose or any terms or conditions inconsistent with the provisions of any general or special law, or take any other action related thereto.
I still think that the latter part of that article is expansive. It's not limited, in my judgment, to personnel, or it can be argued that it's not limited to personnel. If you want to limit it to personnel, it seems to me the proper modification would have been to expand Article 12.
If I could speak to this, I'm concerned with the amendment to personnel that it actually may narrow authority we already have by expressing the will of town meeting that our contracting power is limited to personnel. I think this is an issue that needs to be addressed by town council to explain why this language has been proposed, what it's intended to do, how it should be interpreted. I think this is a very different article than Article 12. Article 12 is a specific amendment to an existing bylaw to carve out a particular position or type of position that is not currently covered by that bylaw. This addresses the authority of this board to contract in certain ways. I confess with this whole discussion, I'm not sure what that covers, and I think town council needs to tell us what her intent was on that.
The selectman's
So
position is supportive
as
of my
a,
interpretation.
As a member of advisory, then, I can simply ask that a hold be put on this, and we can address it on Monday after
But
we
can't we
get...
still vote for 13?
Well, this is 11 right now.
I know, but it wouldn't imply that we can't vote for 13, right?
I'm talking, right now, I'm talking about Article
Right.
11. All right, and so I will do that. And Article 11 will then move to the last session of this hearing, which will be on Monday evening.
Thank you, Madam Chair.
Presumably by then, we'll have advice from town council. Article 12, to see if the town will vote to amend Section 2, application of the town's personnel administration plan as follows. New wording in bold. Application. This plan shall apply to all town departments and to all positions in the service of the town to which the bylaw is applicable, provided, however, 1, that the terms and conditions of employment for any department head or police department's superior officer, and that is the addition, with whom the Board of Selectmen has negotiated and entered into a written employment agreement, shall be governed by the terms of that employment agreement. And 2, sections 12, 13, 14, 23, 24, 25, and 30 shall apply to all employees of the town, whether or not such employee is elected or appointed, is subject to a collective bargaining agreement, or has entered into a written employment contract with the town, or take any other action related thereto. Someone wish to speak as a proponent of Article 12?
This is the article that we've been talking about that exempts the position that was created last year from other specific parts of the personnel admin plan.
Okay.
And if we, sorry,
No.
Mary. So if we accept this article and 13, we've taken care of Lieutenant Bento, right? But we need 12 and 13 to take care of them, not just 13?
Yes.
Because we have to change the bylaw.
Personnel administration.
Personnel bylaw.
Any comment from the floor on this? And any further comment from advisory on this? Okay. All right, I will take a motion to recommend favorable action on Article 12, as stated here.
So moved.
Second.
All in favor?
Mary,
Yes.
point of order. You were saying Monday night is the continuation of this. You know we were going to be going till Monday night?
We are now. No, I mean, that's seriously, I mean, as soon as a hold is put on something, it automatically goes to the final session, which we have scheduled.
But Mary, just a point from my past experience up there. If you wound up, if you're able to get through everything else today, you could include just this item as a public hearing on a regularly scheduled meeting that you have in lieu of the Monday night meeting. So that's just an option for you.
And to point out one other thing, which we had just discussed over here, another reason for 11 is 13 is limited to a particular contract with a particular person for a
Right.
3-year period.
Yeah.
If he leaves or
Oh, I hear
when
you.
that runs out.
And you got to redo it if he stays more than 3 years. Otherwise, we got to tell him,
Well, we'll deal with
Leave.
that, we'll deal with that with 11.
George?
Can you vote on
Fort
this?
Shea, 19 Deerfield Road. Does this substantially, as I read it, substantially expands the power of the Personnel Committee?
I think it's just,
Just to.
It says elected, whether elected or appointed. Now, the only elected employees that we have,
that's existing now. The only change is the addition of the following 5 words, or police department superior officer.
okay. Well, then, let me ask you this. What power does the Personnel Committee have over elected employees?
Sections 12.
I think it's referring to personnel policies about.
You know,
Can you get on mic if whoever's going to talk? should be on
this
mic.
is outside the scope of the article.
well, it is, and that's what I was just going to say, that, you know, I'm not ready to sit here and have litigation going on about the whole
Okay.
personnel policy. This is just to put in 5 words
Sexual harassment. How's that
into
category?
this particular paragraph, and that's what we're dealing with, and that's,
Okay.
Can you remind me if we voted that last motion? I
We
know it
did
was
vote.
seconded. We did vote it?
we did
Okay.
vote it, okay? And then,
13.
no, 12 we're on
The
now.
amendment again, not the motion.
I'm sorry.
So it would be inappropriate for
We
me
put
to
off
make...
11, we just voted on 12. You get up, we're done.
Okay. Thank you very much.
Thanks. Yeah, we did vote on 12. We held 11. Now we're on 13.
Now we're on 13. We voted unanimously on 12. Okay. Article 13. To see if the town will vote to approve an employment agreement between the town and David T. Bento to serve in the position of police lieutenant for the term of July 1st, 2012 to June 30th, 2015, or take any other action related thereto. A proponent.
This is basically the employment agreement, as if we're entering into an employment agreement with any other union, but this is just one single person.
But as we said earlier, if we vote in favor of 11, 13 is irrelevant, right?
Yes, but whether you vote or you don't vote, town meeting still has to vote 11. So we want favorable action on all 3 so that we are able, at town meeting, to get enough votes on enough of these articles in order to actually do a contract with this poor guy who's been waiting 2 years
But if 11 is approved...
by town meeting.
You have that authority.
Yes, and then the
You don't
board...
need 13.
At that point, after the vote at town meeting, we may ask you to withdraw.
Well, we don't
Article
withdraw.
13.
You withdraw, we would vote no action.
Right, but at this point, we're asking for favorable action
Understand.
on
On
all
13.
3 so that we
Well-
have...
Understood.
Okay, 11 is put off, 12 is done, we're on 13.
Yes.
That's where I'm going, okay?
And if 11, just so we're clear, 11 is voted down, 12 and 13 allow the
11 was
town to
held.
approve
Yes, that's right.
Lieutenant Bento's
At town
contract.
meeting. Yes.
And we have a comment from, Corey, could you please?
You don't really withdraw an article. We have to address all the articles that are on the agenda, so you would simply recommend to take no action. And if you wanted to state in the argument that, in fact, the intent was to withdraw by the proponent, you could make that clear.
Okay, thank you. Peter?
Peter Liffin, Dopping Brook Road. This may seem like a small point. I don't know, I'm not sure that it is, because you as a board are being asked to approve a contract. My question is, have you seen and reviewed the contract?
I believe, okay, again, not a lawyer here, but it looks to me like we're allowing favorable action, recommending to the town that they take favorable action. We are not voting, none of us will vote until town meeting, right, as individuals. And so we're recommending to the town that they vote on it.
But you're making recommendations to the town on these articles. My question is, have you seen and reviewed the contract yourselves?
I can speak for myself, I have not.
That's what I expected, and yet this article would expect that you had.
And we've
Not
had a
necessarily.
number of hearings when we've heard about the details of the article, and
Right.
that they've entered into an agreement with Lieutenant Bento that they can't fulfill because of this, I guess, technical glitch. So I've heard enough from the chief and others that I'm comfortable that the guy's contract should be approved.
Yes, and we had executive session the other night, we've all approved the contract. That's part of what we're here to do, that sort of thing. It mirrors basically where he would be otherwise under the union contract, so it's nothing beyond what he already is.
I would add to what Peter said, that was a perfect argument why you should approve Article 11, so that we don't have to go to you with all these contracts for you to spend your time reading, and all the voters have to spend their time reading at town meeting.
Jeff, did you want to say something? Peter?
I'm sorry, Peter Liffin. It's just such a rare circumstance. I had to take advantage of it because I agree with Mr. Durensis. And
Okay, we're in violent agreement.
We got that on film, didn't we?
All right, we're in violent agreement here. So, I will take a motion to recommend favorable action on Article 13 as presented here. Do I have a motion for that? Second?
Second.
Any discussion here?
Could we hold this because it seems paired with Article 11?
Okay, if you want it held, it's held. All you have to do is ask. Okay, that is held until Monday night.
No, but why, I don't understand why Monday? What if we?
Well, till the final session of the hearing. Okay,
Which could be today.
it could be, okay.
You would have legal counsel here
Counsel,
today.
right,
for
that's, yes,
11.
right. We'll be no better off at the end of the day.
But it could be our next regular meeting.
If you could, I was going to ask you if you could give us a sense. We've been jerking this guy around for the longest time. The uncertainty, if I were in his shoes, would be killing me. Do you have any real issues with the substance of this? I appreciate the need for a hold, but I'm just curious to the extent there's some sense, so the chief can go back, he has to deal with him, he's a big guy, you know?
Carries a gun.
Yeah.
I would ask the vice chair to consider withdrawing his whole motion, because I agree. And indeed, if we find there's some issue, we're coming back to this issue anyway, we could undo our vote. I believe that's allowed from a parliamentary
That's
point of
fine.
view. I recommend favorable action.
Is that okay, Corey, that he can withdraw his hold?
Oh, sure, that's a convention of the
Okay.
committee, that's wonderful.
Okay. All right, I reiterate. I asked for I'm starting, I don't care if we've already moved and seconded, we're doing it again. To see if I am asking for a motion to recommend favorable action on Article 13. Do I have that motion?
Don't move.
Do I have a second?
Second.
All in favor?
Thanks a lot.
Okay. Article 14. To see if the town will vote to transfer $11,000 from, and this is the wording, Odessa in the treasury of the town. And it probably means Odessa funds, I am sure, for the purchase of a speed alert radar message board for the police department or to take any other action related thereto. Rick?
Point of information, what does ADESA stand
Oh,
for?
I have no idea. And it is
It's the name of the company.
it's the name of the company, and it is up on Framingham border there on Western.
I don't think it's an acronym, it's just the name.
So after all this talk, I was thinking, if we took 15 lawyers, put them on a raft, and set them out to the middle of the ocean.
I'm with you, Rick. 100%.
Put a police officer there to keep order.
I'm sorry, did you state your name, sir? So, actually, I have to give full credit to the Chair of Advisory, Mary Wolf, for convincing me to pull this out of a capital item and looking to have the town seek funding from the Odessa Fund. I thought that was a great idea. So, I put up on the overhead here the product that we are looking to purchase through a state bid list. It is this product over here. It is a speed and sign board that we are in much need of replacing. The speed trailer that we have currently is not functioning, and it's costing us roughly $300, $400, $500 a year to maintain it. Whoever purchased it before made a tremendous mistake and didn't purchase a warranty plan with it, so it's always out of pocket. Frankly, we have a tremendous amount of requests from residents across the town to put these up in different neighborhoods where children play and where people are concerned about the speed and whatnot. So this particular product, I have to give full credit to Acting Lieutenant Bento. He went out and researched this information, and he researched this product, and he brought back what I thought was perfect for our town. Not the most expensive product, kind of middle of the line, but it certainly has a lot of applications. We can access this unit from home, from a smartphone. It collects data, so if we want to go up to Woodland Street and trap how many trucks drive down Woodland Street, we can do that. It gives us the opportunity to identify problem areas in the community where people are speeding at certain times of day, during certain days, as well as times during the day. Ultimately, we, as I mentioned, we use this product often when it's working. So I actually, let me get into that. I actually wanted to show the public the quote that we received. Again, this is from a state bid. I wanted to point out that this particular company has given us a $1,650 credit. To the piece of junk that we have out behind the station right now. And ultimately, we are going to, I don't know why this says 10-100, but ultimately, we are going to purchase a warranty plan with this product. We get 2 years free warranty protection, and beyond those 2 years, we're going to be investing $1,500 into a warranty plan so we can make sure that the product is working properly at all times.
And would you care to address how that's going to be paid for? Because we talked about this.
We did talk about it, yeah. I'm going to be looking at the Odessa Fund to pay for that warranty moving forward.
How long is that for?
I'm sorry?
How long does the warranty last?
As long as you pay for it.
It appears to be warranty plus maintenance and upgrades, software upgrades.
That's it.
All right, is there any comment from the floor? Okay.
If I may very briefly compliment Mary if this was her idea of the source and the police for finally using that money for the townwide benefit.
Ruth Owenchaw, Town Accountant, 7 Snow Street. There is no ADESA fund. The money goes into free cash, and with the intent that it will be used for traffic calming purposes throughout the town. So the money actually comes from free cash, but it has been received from ADESA in fees that they've paid. Just want you to be.
I think what we wanted to accomplish was to say we're not just dipping into free cash for this, but that we're using funds targeted for this type of thing.
Paul Hodman, 99 Maple Street. I'm very concerned about traffic in Sherborn. I have been for 36 years. And it sounds to me like this device is just a substitute for citizens calling the police and informing them about speeds, about different situations on the road. So this sounds like it's probably not that useful, but one thing I would like to see the police ask for, and I've suggested this to the Board of Selectmen, are decibel meters. Because every time I call the police about noise, for the last 5 to 10 years, they always say we need decibel meters.
Okay.
When are we going to get decibel meters?
Noise is not within the 4 corners of this article, so I'm going to ask you to.
Okay, well, the first part of my comment stands.
Okay, thank you. Susan?
Susan Tyler. I just want to say that Traffic Safety Committee has discussed this, and we fully support it.
Selectmen support it.
Any comment up here from advisory? Okay, further comment from the audience? Okay, then I will take a motion to recommend favorable action on Article 14.
So moved.
Second? All in favor? That was unanimous among the people present. Okay, the next 3 articles are the result of work by the Governance Task Force, and it had been my intention to talk a little bit about that, but I think I would prefer to cede my time speaking to someone who really knows what they're talking about, and that would be Kitty Sturgis, who is the chair of the Governance Task Force. So before this is just a minute or two before we start talking about the individual articles that have come as a result of the Governance Task Force's work this year.
Thank you, Mary, and thank the advisory committee for giving me a couple of minutes. First of all, I'd like to call our committee to order. We have been posted for today, but we have not been formally called into meeting. Okay, I want to introduce the next 3 articles for your consideration. They will be discussed individually. A motion approved at the 2013 Sherborn Annual Town Meeting creating the Governance Task Force during the deliberation of Article 23 of last year's town meeting. The town moderator, Corey Lincoln, after consultation with the Board of Selectmen, appointed a task force of 5 registered voters to recommend changes to the town bylaws dealing with governance after considering the recommendations of the Massachusetts Department of Revenue and the Collins Institute reports. Appointed to the Governance Task Force were Ron Rego, George Shea, Kitty Sturgis, Rob Tierney, and Chuck Yon. Members of our committee have interviewed numerous town administrators, town managers, former Sherborn town administrators, Sherborn town officials, and authors of the Collins and the Department of Revenue reports. Interested citizens attended nearly all of our meetings and shared their comments, observations, and suggestions, and I thank them for their time. The following articles, and I believe they are now 15 through 17, that has changed a lot over the last 10 days, and Ron Arrigo will discuss the town administrator job.
Thanks, Kitty.
So let me read the article first, and then you can address it. Thank you, Kitty. Oh, this is the one that is very long. Okay, yes. I was looking at the first paragraph. thought the next thing was the second article. So yes, by all means, we can waive reading, please, of this. So as stated here, this is the, basically, the definition of the town administrator's job description.
Yes. Ron Arrigo, 41 Ivy Lane. So I am going to, as Mary mentioned, I'm going to address the proposed changes to the town administrator job description. I have 5 slides. I'll move through quickly and then proceed. There are several reasons to consider a change to our current construct of the town administrator job description. First, as Kitty mentioned, based on the town's interest in seeking advice from the Collins Institute and also the Department of Revenue, the DOR report dated May 2012, and the Collins Institute dated 2011, both recommended a change to codify the position of a quote-unquote strong town administrator that would allow for a much better means of centralized authority within the town and within the town administrator position. In our work, as Kitty mentioned, we sought best practices from other towns, which include Needham, which isn't necessarily comparable, but nonetheless was cited as a best practice town in the design of their town administrator job description, and also Lincoln, which is certainly much more comparable to the town of Sherborn and operates in the construct of a strong town administrator. Additionally, another reason to consider the change is it allows for the Board of Selectmen to be more visionary in managing the affairs of the town, or at least certainly working to align a strategic plan to achieve that vision. It would minimize their involvement in the day-to-day responsibilities of the town, shifting that to the town administrator, again allowing them to be more visionary and strategic. The TA position as proposed would align to the recommendations, again, from the DOR and the Collins Institute. It proposes, as written, that the town administrator, the strong TA, if you will, would operate as the chief administrative officer for the town. He or she would be accountable for managing the town's business from a day-to-day basis, day-to-day business perspective. He or she would supervise, direct, and be accountable for all areas and employees that fall under the Board of Selectmen, but would not include elected officials, committees, boards, commissions, and so forth. It also would exempt the police and fire departments. For those departments where the TA is not accountable, he or she will establish effective working relationships among all town departments, employees, and so forth. So acts as a relationship or a liaison type person to make sure that the operations of the town are run efficiently and effective. And then lastly, the town administrator, as proposed, would appoint and remove employees who fall under the BOS only. This article would bring about a much-needed change regarding the management of human resource matters. The strong TA would operate as the human resource director for all town employees except school employees and the Board of Library Trustees. He or she would administer the personnel administration plan and would collaborate with the Personnel Committee. They would ensure consistency in managing personnel system, including job descriptions, the pay practices of the town, and performance appraisals. So earlier this morning, if you remember, part of a discussion about the philosophy of the town being competitive in pay, and a hope on the part of advisory that we would have an update, a more relevant analysis of pay practices. This answers that. This puts this in the accountability column for the proposed town administrator, just as an example. Also, the town administrator would review all hiring and termination actions. He would or she would be responsible for managing the investigations of improper conduct as outlined in the personnel administration plan. And then lastly, consult with town council as necessary. The additional responsibilities include the strong town administrator being the chief procurement officer. So this will bring about greater efficiencies, allowing the person to oversee the purchasing of all equipment and supplies for the town. Also responsible for bidding, reviewing, and awarding all contracts, not including the schools, as allowed by the general laws as cited. And then lastly, execute on all contracts, except those related to schools, audits, and town council. So in summary, the benefits are many. The BOS, the Board of Selectmen, are able to focus on the creation of the vision of the town and facilitating a strategic plan. As the Chief Administrative Officer of the town administrator has the necessary autonomy and authority to execute on the vision and the strategy as set forth by the Board of Selectmen. The town benefits from a named Human Resource Director who is accountable for consistent administration of employment-related matters. And then lastly, efficiencies are gained with a Chief Procurement Officer responsible for ordering of equipment and supplies and the bidding, awarding, and executing of most contracts.
Good timing. Very good.
job.
Yep.
Okay, so I will open it up first to comments.
Friend of dog this morning, yes.
Comments from the audience?
Michael Lesser, Forestry. I'm speaking as a Conservation Commissioner. For whatever reason, you had your finger on this?
I'm just waiting on.
Oh, okay. For whatever reason, this is only coming to light now as a Conservation Commissioner. How that process of communication should go is another thing. But in the past, when there were some articles like this, there was the issue that for staff of appointed boards like the Conservation Commission, that there was some... Okay, there was the ability to jointly discuss, jointly agree on the hiring of the staff. We work very closely with our staff. The way it's written now, it seems that the town administrator appoints the staff only with some recommendations, whereas previously you had to agree on the appointment between the appointed board and the town administrator, which would give a little more balance to that, especially for groups that have to literally depend on and work day to day with the staff, that it would be nicer, it would be much more efficient. I think it might be a more efficient working relationship if there was an explicit agreement and that the commission itself had its own say in the staff as well, along with the town administrator, which I don't see in the way it's worded now, and where that kind of, where that could be added to this.
I would invite some other committee members to make comment on that as well. So certainly, I appreciate your comments, Michael, and it certainly would be the intent, as we mentioned, in the job description that we're proposing, that there would be collaboration, as far as recommendations coming forth for committees, boards, and commissions. So that's our intent. It would be collaborative.
But collaborative doesn't basically, I mean, in the end, push come to shove, when things do get difficult, you'd like to have some real bite, or not bite, just effectiveness for the commission to basically have its say, or at least negotiate something, but otherwise we don't have that. So is there any way to change that?
Excuse me, I don't read this, I don't read this bylaw that way at all. I read this bylaw as giving the town administrator such hiring and firing authority with respect to those employees within the jurisdiction of the Board of Selectmen, with respect to, and specifically excludes that hiring and firing authority over non-Board of Selectmen committees or commissions.
That's correct.
We're not an elected committee.
Just elected.
You see, we are an appointed board. That's why, if I understand it right, unless I'm missing it right, I mean, I'd like to be wrong,
Who appoints you?
but
Who
we are
appoints
an
you?
appointed board.
Appointed by whom?
The selectmen.
Well, there you go.
Yeah. What does that mean?
My simple-minded view is if the Board of Selectmen has jurisdiction over a committee or anyone else, that they have authority to arrange for the hiring and firing of those people. They are the ultimate authority. with
That's your
respect to
opinion,
those
but right, I would think for a committee that basically has to coexist with this person, that we should have a little more say than that. That's just very simple, and that we should be explicit. I mean, I agree with collaboration, and that's the ideal, but that doesn't always happen.
I wouldn't assume, though, that although the TA has that authority, that they would be averse to a collaborative relationship.
Agreed.
It's only in a matter of when things, most things only come down to it when there's a problem. And that's where you
So, Mary,
But the TA shall consider the recommendation.
It's been in the past an alternative. I would like to see that.
Okay, Michael, you're 15 minutes.
no, I just want to speak in general
Peter?
terms, not on that particular topic, but just
Well,
that...
no,
no.
then come back
Oh.
to me at another time.
Oh, you want to deal with his thing?
No, I wanted, oh, no, you're going to speak to this article.
Yes.
Okay.
Yes. No, so I want to thank the Governance Task Force. I know that they worked very hard to get to this point. They came before us as well, and we discussed all three of these articles. On this particular article, we noted when they met with us that they had utilized a number of the provisions that we had gone through last year that we tried to bring forth to town meeting, so that it was good to see. And we had raised a couple of points. One was to clarify which groups were excluded from the TA's thing, and they, mentioned the elected official, boards and committees and so forth. The only thing that still has me personally, we had discussed further on, was the timeframes on the paragraph being added to 6.1. That I'm concerned they're a bit restrictive, where we talk about 60 days, within 60 days of occurrence of a vacancy, we have to appoint an interim administrator for a term not to exceed 90 days. So all of those dates in there I find restrictive. And so they asked, when I raised that with them before, they asked, well, what do you have as an alternative suggestion? And I said, I don't know. I mean, if push came to shove, I could say, well, you know what I'd do in all of these? I'd say I'd write out the number 60 and 90 and 60 and 14. I'd eliminate the second digit and just use 6 and months as a suggested alternative time frame, which,
And I would just comment that the intent of the days listed was to ensure that a process was enacted to find a replacement for the vacated position. So the days it allows for 14 days to post the position. So the position goes vacant on July 1st, it should be posted by July 14th, and then as written, as proposed, it allows for 60 days to name an interim town administrator. So up to 2 months to find a person that's suitable to do the role. And then that person, once named, can operate within that position as an interim for 90 days. And if the search for the full-time replacement went long, this proposed wording allows for an extension of that time for another 60 days, which, based on our committee work, is ample time, we think, to field a committee of townspeople to find a replacement.
Okay, great, thanks. Any other comment from?
Ted Wong at 129 Maple Street. Just a quick question. Who has oversight of this town administrator? Does the Board of Selectmen, at their discretion, they may remove him if there's some disagreement?
Yes, that's my understanding.
That's in the bylaw, because I don't have a copy of the bylaws.
Yes.
On majority vote. Okay. Great.
Any other comment there? Betsy?
Betsy Johnson, 272 Western Avenue. Following up on Mike's comments, if push comes to shove and the town administrator likes their agent and they don't like the agent, or vice versa, who has the final say?
Town administrator.
Okay.
Grace Sherborn, Rockwood Street. I think we have to remember that the town administrator is not a policy creator. He is a policy administrator. And therefore, his actions in hiring and firing within the context of the Board of Selectmen boards is to try to implement Board of Selectmen policy. So the policy of any committee that is appointed by the Board of Selectmen should reflect the Board of Selectmen's policy. And if the town administrator doesn't act within that context, he's in trouble with the Board of Selectmen.
Point, Bruce. Any other comments? All right, is there a comment up here?
David, I don't think we've heard from you on this. I assume you would dump a lot more work on you, or maybe just solidify what your responsibilities are, but I'm assuming you're behind this, or how do you feel?
The governance committee met with me a couple of times. And the governance committee met with me a couple of times, asked many questions, and we've been going back and forth. And I've provided honest answers. I'm not going to say whether I support or support an article that's it's really up for the town to be putting it forward. There are no changes in this that I would make. That's all I can say.
Any other comment from out there?
I'm a little concerned by the comment from our Conservation Commission, which leads me to think that maybe there are other boards and committees who haven't been consulted. One of the criticisms that we had last year was when we were working on government change, a lot of people came in and said, well, you didn't talk to us, we understand how this would impact us. And I want some assurance that you've circulated this to all the town's boards and committees. I mean, you make reference, for example, to the personnel board. Have you met with the personnel board with this? And other boards and committees. Have you kind of done the circuit with this, or are we going to catch everybody by surprise, like apparently the Conservation Commission was caught by surprise?
Well, certainly, all of our meetings were posted. We've met for the better part of 7 or 8, maybe even 9 months. We vetted it with the Board of Selectmen. We spent time at an advisory meeting speaking with advisory. We did not specifically make appointments to talk to any one board or commission, no, to the best of my knowledge.
No, we have not.
No.
Is this something new, Michael?
Yes,
Okay.
going forward, Michael Lesser, Forestry. I guess the whole problem in general whenever a board is meeting is how proactive you are in contacting any committee or board that you are impacting. And I think it's important that any board be proactive. The reliance on the fact that it's posted as a hearing, you don't know what's there, we're all overcommitted in terms of town stuff, so that I think it should be a general thrust that you're much more proactive in going towards committees, or at least sending a material when they're going to be impacted. So that I don't feel like I'm coming and doing this at the last minute, which is in some ways difficult for people.
Susie?
Hi, Susie Tyler. I just want to state that having been on the Conservation for 4 years, the Conservation Commission agent is a town employee. The commission and the agent comes under the Board of Selectmen. And I would hope that the town administrator is given the ability to deal with the hiring and firing of an agent.
Grace?
I wonder if someone could clarify for me, how many committees are there that the Board of Selectmen appoint which actually have employees? Please? Are there any others?
Well, Council on Aging.
Council on Aging. So that, is it the two committees that, if there was an idea of consultation, there should, is it that too? I mean, I just want to clarify how much of an issue this is.
Okay.
Just Council on Aging and Conservation Commission are the only two that have budgeted employees.
Okay. All right, so sorry.
I will make, Kitty Sturgis, I'll make my personal guarantee, I will do the road circuit to those two committees.
So if there is no further comment, I will take a motion.
Can I just,
Do you have- sure.
just a question. Did the Board of Selectmen support this?
We have not voted on this in support. We held in part because of the questions I raised earlier. Certainly if the board wants to vote on this. I think in general terms, it's fair to say that we're comfortable with it. I just had issues with the time.
I had the same issues with the timing, but otherwise in concept I support this. We have not taken a vote because of those issues.
Yeah, just, it would be useful for us. I mean,
Well,
if the Board of Selectmen say, we hate this for X, Y, and Z reasons.
We're not saying that. We just...
No, I was using it as an example. But it would also be even more useful to know that the Board of Selectmen supports it. It would make our decision-making more meaningful, I think.
Well, I think we've shared with you what the concerns are.
We support it subject to those concerns, I guess.
Yeah.
It's like saying we support it except for the parts that we don't.
Jeff, it's a very discrete part, but that's accurate. That's accurate. We do support it except for the parts where we don't. We do think those time standards, like with any kind of legislation drafting, there are pieces that people don't like. It's not unusual. And in this case, those timeframes seem to us as a practical matter to be a little bit too short.
And I get that, so I guess what I'm saying is it would be useful, at least for me to understand. By the way, I share your views on that first article on the time. I expressed that to my friends at the task force at the time they were creating it. I thought it was unnecessary and perhaps a little confusing, so I share that. But notwithstanding that, we have in front of us a warrant article, okay, a bylaw change. So it's useful to me to know whether, given your misgivings, would you want us to vote in favor of it, or your misgivings are so great that you would like us to vote against it? That's I think, a meaningful
I don't know
question.
how to advise you personally on that. Seriously.
You have a third alternative?
I mean, you've amended motions before, and I think the sense you'd get from us by those comments is we would be more comfortable if you amended this or recommended amending it to have those time frames extended.
Yeah.
All right. I will, yeah. To what?
Well, the simplest.
And I'm not saying we will.
I understand. I was to put it out more in months, so 6 months where it says 60 days, and 9 months where it says 90 days, and
So
1 month where it says 14 days.
And that brings the entire process, were it to run its full course, to a year and something. That's a very long time, it seems to me, to be without a town administrator. We've had
That's fair.
that problem before, and I don't think it has worked out well for the town. I'll just make that my personal statement.
Here's one question, there's no remedy nor penalty. The time frame goes longer, for practical purposes.
What happens if you don't find somebody in the
No,
time
just
that's
won't
here?
talk it through.
That's the concern we have.
What happens if you don't?
Nothing.
Again, the intent of the timeframe was meant to be a guide, you know, to have a sense of urgency,
Right.
that all stakeholders work in concert to find a replacement.
Why don't you say that? That's the guide. Right now, it's mandatory. So there is a concern that 60 days runs by.
Here.
Talk into the mic.
There would be a legal concern that you get to the end of the 90 days and the 60 days, and let's say you've selected somebody, but he decides no, and he leaves, or doesn't take the job. Then what?
Well, it says you can keep reappointing
Yes.
someone.
Yes.
That's what it says. You can keep
Yes.
reappointing someone.
You can extend.
I thought it was just one 60 days.
Yeah.
It says an additional
60
60
days.
days, so maybe that should say for additional 60-day appointments.
It says reappoint.
One thing we pointed out to the committee when they came in was that if you're going to get somebody who's good, they probably have another job, and you may have to recruit them away from that job. And it may not be practical to do that in 60 days. It may be practical to do it in 90 days, or it might be practical to do it in 30 days. We don't know. But these are arbitrary numbers, and our sense is they operate in a way that may be too stringent. I mean, I like Paul's suggestion of having it aspirational rather than mandatory. All you can do if we don't hit these numbers is come in and tell us that we didn't do our job, or whatever Board of Selectmen is, didn't do our job. But why set it up so that you're in that position?
Do you realistically think that someone with a job is going to abandon that job for an interim appointment?
Well, that may be another issue.
So,
But even, Mary, just think practical purposes, take the 14 days. Let's say David decides to run off into the sunset and cruise away with his family. And now we have 14 days to go to market to find somebody?
To post it.
Well, even when you post it, I think back to when we were posting for a fire chief as an example. You know, the fire chief, the former fire chief would come in and say, here's how we're going to post this thing. Have somebody, the Board of Selectmen, you know, you have to schedule a meeting, you have to deal with it.
well, you have a job description now, so you'll just be able to post it.
But, you know,
Uh,
I don't know what posting necessarily.
Excuse me, David has something to say here.
I just wanted to say my contract requires an advance notice if I was going to run away with my family. And if 90 days or 120 days.
How about if you're just going to run away?
Where'd you go? Nothing else to go with you?
And if I may just make an observation here, one of the reasons we proposed to make this a bylaw and not go to the general court was that we felt if this is really a problem for the selectmen on timing of finding a new TA, and they need to change that wording. We can keep it in-house. We don't have to go to the legislature to ask for permission to expand that.
Yeah, it seems to me that this is an issue that we've been addressing now for multiple years, and since this does not, in fact, have to go to the general court, my inclination is, let's get something here, start working with it. If it proves to be unsuccessful, we can go back and re-examine it. But I'm personally in favor very much of moving forward. Robert?
Robert Johnson, Western Avenue. Going back to what was discussed a little bit earlier, I'm in favor of agreement between the town administrator and whatever committee is involved relative to their employee. I think that it's very important for the committee to be comfortable with the employee. And so I would hope that some wording could be changed or added to make it be an agreement between the two rather than unilateral.
Okay. If there is no further comment.
Mary?
Is- Oh, I'm sorry.
I just wanted to ask, I used to have that job, and who do you work for? If you,
Which job, Barb?
conservation agent.
Okay.
Who would I work for?
The TA.
And the people who told me what to do all the time don't have anything to...
It's part of the collaboration.
That just creeps me out.
Bob Delaney, if there is a disagreement, somebody has to be, to take final responsibility.
Buck stops somewhere.
Exactly. And, we're voting on a strong town administrator, and it has to be him.
Okay. I'm going to close the comments on this now. Because I think from here is fine.
Yeah, I mean, is there a grievance procedure, since we're creating such a strong town administrator? Is there some recourse, because he's both the chief executive and the human resource person? I mean, there's somewhat a contradiction in that.
Yep. Yes, the personnel administration plan speaks to that. So if there are issues, regardless of strong TA or the current job description, the Board of Selectmen would be one, or town council.
All right. I will take a motion to recommend favorable action on Article 15 as written here.
I so move.
Second? All in favor? Okay, so that is, everybody, okay, unanimous? All right. Moving on, Article 16. And okay, and this is an article to allow the town administrator to approve warrants for the payment of town funds. And if one of the proponents would like to speak to that.
See how good you are, George.
Yeah, you're done, George.
Nobody's going to listen anyway. Time's up.
There should be a
Microphone, we can't hear you, George.
Just if
Not many people have ever said that to me.
You're among friends, George.
Can you hear me now?
We can, George.
Okay. There isn't much, shouldn't be much controversy over this particular article. It's practically a paraphrase of what the Board of Selectmen put in last year. It is a separate article only in the sense that it needs special legislation to be enacted to authorize the Board of Selectmen to delegate their responsibility of signing a warrant to someone else. And that's why it's in a separate article as contrasted with the Board with the job description of the town administrator. and answer any questions you need to have answered.
Okay, is there comment? You get
Yes.
points, George, for finishing early.
Thank you very much.
Yes, once again, we support this except for, again, a timing issue where we have a 7-day window to deal with anything that we've pulled away from the payment schedule. And we think that 14 days would be preferable. I thought we had discussed that with you guys. And maybe you chose not to change that.
Well, we ran into some difficulty with wages, and at the time, we didn't have any information that all employees were going to be paid on a bi-weekly basis.
Yeah, which we are, and we mentioned when you met
Right.
with us.
So are you okay with 14?
I'm not all by myself capable of changing anything.
Well, so we recommend changing that.
But you have a
7
committee,
days to
you have a
14
committee in
days.
session.
You have a majority, you have a quorum here?
We have a quorum.
Okay.
George, no issue.
We're fine with that.
Thank you. We support this article with that change.
There you go.
Okay.
Finished now?
Oh, are you finished?
Yes.
Great, George, you just great.
I have to apologize, I'm getting used to my hearing aids, and so I don't know how loud I'm speaking, because it's a different sound than it was without them.
Interesting. Well, I wish you good luck with them, George.
Yeah. Okay.
Are you going to take a vote?
Yes, I am. I didn't know if Chuck was speaking
No.
to this or what.
getting ready.
Okay, but someone is.
So Michael Lee, 28 Wildwood Drive. We still have school committee members signing warrants for any school expenses, and I don't know whether that factors into efficiency and whether that, which is the best practice. Just put that out there as something that's different than this practice.
No, this won't be
I don't
different.
know the merits.
Yeah, you'll still be doing it. Department heads, and in your situation, the school committees would be approving.
No, I
those things
understand that
come
these are
to-
separate. I'm just wondering what is the best practice, and if it's best practice to do it this way for town expenses, does that beg the question of?
We
should that be
do
done for
every
schools?
dollar that gets paid by this town for anything is approved by us, including all school payments for salary and items, library, books, all these, every payment must be approved by the Board of Selectmen.
Okay.
And that article is enabling him to do that in lieu of us, but giving us rights of review and pullback to the extent we have issues, which is fine.
All right, is there comment or questions from advisory on this? Okay, then I will accept a motion to recommend favorable action on Article 16 with the, we don't need the change now, is that correct?
You do.
Okay.
Word 7 to 14.
Okay, with the change of 7 to 14 days.
Second.
Okay, all in favor? Right, unanimous. All right, Article 17. This is, okay, again, a somewhat lengthy article, but it is to see if the town will vote to change basically the number of the membership of the Board of Selectmen from 3 to 5. Chuck, are you speaking as the proponent?
Yes, thank you. As Kitty and Ron both indicated, we spent a lot of time surveying other towns and particularly town administrators, trying to identify best practices. One of the things in the Collins Institute at UMass Boston, one of the things that they recommended that we consider is expanding the size of the Board of Selectmen from 3 to 5. And we were surprised in our discussions at the number of towns that had made the move from 3 to 5 and found it to be very helpful. There are a variety of reasons why they felt that it had been an improvement, and I'll walk you through some of those. The towns that are listed there that have done this recently are Southborough, Harvard, Sudbury, and Newbury, which are comparably sized towns. I think one of Paul's clients, Foxborough, recently did it as well, but I didn't list them. They're not really, I don't think they're a comp for us. But the rationale was that the larger the committee, the broader the representation. It's a town board, much like the advisory committee, that requires a huge time commitment and volunteers. The skill sets and the expertise that people bring to the committee, with a 5-member committee, it expands it. We lawyers are well represented. The planning board, this board, and other boards, but people with, there are lots of different priorities for people in town, environmental issues, recreational issues, the schools, traffic safety. The broader the representation, the more people that you have, the better able you are to have those interests represented and those expertise and skill sets broadened. The other thing that at least 3 of the towns mentioned was that the perception among townspeople, particularly people being willing to serve on the Board of Selectmen, is that a 5-member board shares the workload. And somewhat counterintuitively, I was concerned from the very beginning about the ability to find candidates to run. So I've listed at the bottom a couple of the concerns. There are clearly, in our committee's views, substantial advantages to having a 5-member board. There are also concerns, some of which were articulated by our Board of Selectmen. You have more members, you certainly have the possibility of longer meetings and more extensive discussions. Depending on the quality of these discussions, that can be good or bad. At the end of the day, one of the things we were struck with was both in drafting the town administrator bylaw and this, ultimately what really matters is the ability to attract and retain a good town administrator and to attract candidates to be members of the Board of Selectmen and that are willing to do it. 3 of the towns we talked to, the town administrator in Southborough in particular, opposed initially expanding the board to 5 members because he was concerned they would not get candidates, and said that he's been very pleasantly surprised that they've had candidates, had no trouble finding candidates. Part of it may be that fundamentally these are volunteer positions, and I think people are adverse to running in a contested race. But the other thing that I personally found persuasive is while I recognize that the comparison is not perfect, if I'm representing a company and advising them on the side of their board of directors, 3 is a tough number. There's lots of organizational dynamics data suggesting that 5 and 7-member boards work better. Bain Capital did an analysis a couple of years ago for nonprofits, and their conclusion was 5 and 7-member boards work better. Another advantage is that with a 5-member board, it's easier to schedule meetings. If 2 members of a 3-member board can't come, you don't have a quorum. The expansion of the board gives it more flexibility. A number of the town administrators we talked to said that they are more comfortable working with 5-member boards. There tends to be a little more continuity in strategy and direction. With a 3-member board, a change of 1 seat can change the focus and direction of the town. Obviously, these are elected positions, so the town ultimately has the control. As Jeff said quite ably in a number of our meetings, at the end of the day, if you're not happy with an elected official, you can vote him or her out. But, yeah. So our goal was to identify what we think the best practice is and the best structure for the town. And that is why I will not sit here and tell you that there aren't pros and cons. Our vote was 4-1 in favor of it. I think it's unrealistic for anyone to suggest this is all bad or all good, but we strongly endorse it and urge approval by your board and town meeting.
Okay, thank you. Comments from the floor?
Sure.
Okay.
Sure. Yes, so speaking with a little experience as a Board of Selectmen member, we took a vote, and our vote was 2-0-1 to take no action on this. And some of the reason, I'll let Mike speak to the extent he has anything, and Paul can certainly speak to it, but from my perspective, the concerns I would have, and I try to look at it from what I think is in the best interest of the citizens of the town of Sherborn. Sherborn is a small town. Another small town, but 50% larger, is where there are plenty of good examples of 5-member boards. There's plenty of good examples of 3-member boards. Our sister town over across the river has a 3-member board. They're larger. They're very well run. Lincoln, I understand, has a 3-member board. They're very well run. So we're a small town, and perhaps that's one reason why a larger board is not necessarily necessary. But from my perspective, I would, clearly, as Chuck alluded to in one of his slides, it would provide the opportunity for less efficient meetings and government and so forth. I also think the opportunity would be there for less transparent government and the opportunity for greater opportunities for behind closed doors government taking place than what we try to do is do it all right here at the table. So we certainly respect what people think. It's up to the residents of the town what they think, but we voted against it, and hopefully that helps your thought process or confuses it further.
Chuck?
Mary, I'm sorry I didn't time this nearly as well as Ron did. Peter's absolutely correct. There are a large number of towns with 3-member boards, particularly out west and in central Mass. In eastern Mass, I got the data from the Massachusetts Municipal Association. It's probably 2/3 or 3/4 have 5-member boards. Here's a listing of neighboring towns, and Peter's absolutely correct. Dover, Holliston, Millis, Weston, Westwood have 3-member boards. The list on the left side, I tried to do comparably sized towns. And if you look statewide, it's a pretty even split. The disparities between the western part of the state and the eastern part. Yeah, well, that's...
Depends on the week.
I'm from Cook... Paul, I'm from Cook County originally, so double counting is irregular. And this is a problem with me doing the typing, so I can only blame myself.
Well, I think they have a 3-member board.
You're right. Yeah, they should be only on that right side.
They're not on this one.
All right, so further comment from
Yeah, I
Mike?
would just echo Peter's concerns and also point out I am concerned about willingness of enough people to run. We already have problems appointing people to appointed boards, which have a lot less of a workload and a lot less frequent meeting schedule. So that to me is a concern. And I also wanted to ask, just as a point of information, you mentioned talking to towns that had gone to 5-member boards. Did you talk also to towns that had 3-member boards and explore the same kind of issues with them?
Yeah, we spoke to the folks in Holliston, which is a 3-member board, a very good TA and a reputation for being a very well-run town. So, yeah, we did. We spent a lot of time talking to folks in Dover, and their TA bylaw is like 3 lines. De facto, he has been very successful. So it's a great point, Mike. At the end, ultimately, what you want is the best town administrator that you can attract and retain. You want the best volunteers that you can get for run for all of these committees. I also just did a quick listing of the existing 5- and 9-member boards. Having served on advisory and planning board, our meetings are, they're pretty well run, pretty effective. So I don't think there's any magic to 3, 5, 7, or 9.
Yeah, I think that the difference is there could be a tendency on a Board of Selectmen that's larger to be a more political board. And I have seen that in other places that have 5-member boards.
Yeah, there's certainly, the politicization of the Board of Selectmen can happen whatever the size is. A couple of the towns we talked to that went from 3-member to 5-member boards did it in part because the perception was they had a 3-member board that was not functioning well. It had a lot of conflict, some of which we've had in the past. We certainly don't now, but the broader the board, my perception is, the better chance you have for achieving a consensus, if not unanimity. But I think that's a good
I think in our case, our town's case, we're fixing a problem that isn't there, but I do appreciate there are arguments on both sides of the issue.
Okay, any further comment here? Elliot?
Quick comment, if we go to a 5-member board, only 2 will be attorneys.
You don't know that, Elliot. It depends who runs.
That was not in our recommendation.
Bob Searle, 32 Old Orchard. This may be a naive question, but just reflecting on your comment about worried about getting people to run, and then looking at our population relative to most of the towns, we have, by the 2010 census, I just looked it up, 4,200 people. Most of the towns up there are many multiples of that. So what happens if we don't get anybody to run? I don't know if that's a possibility, but what would happen in that case?
Well, just to clarify, about half of these are towns of 4,800 or less.
Okay.
Because Absolutely, that's let's try and compare apples to apples.
That's his math about.
There's a reason why people don't run.
Bob Delaney, Pleasant Street. One of the comments was time commitment. One of the purposes of the town administrator's job description as a strong town administrator is to take more of the nitty-gritty of running the town on a regular daily basis goes to the town administrator. It eases up considerably, I would anticipate, and I think that is anticipated on the Board of Selectmen. So that would enable them to be more policy-oriented rather than operationally oriented. And finally, a personal opinion. The comment was made here that while in the past the three-member committee has had some problems, I don't perceive that now, so I guess I would say if it's not broken, don't fix it.
Peter?
Peter Liffin and Dopping Brook Road. It's interesting to hear these arguments go back and forth. I'm of the opinion that frankly you'd find it easier to find candidates for a 5-member board. I know that 3 years ago Paul ran with an opposition candidate. I know that Mike was an opposition candidate when he ran. I don't think there's a problem finding people that want to do the job, that have the best spirit of the town in mind. And so I would say that, really you're going to have no problem finding 5 people. And with 5 people, I've also heard it said, the board then must, in fact, work a little harder to build consensus. I think that's a good thing. I think the board should have an effort, Board of Selectmen should have that responsibility, have that burden on them to build consensus to get to a solution that doesn't have to be unanimous. So I certainly would be in favor of a 5-member board.
Are you, Susan?
Do you have a question for him?
No,
Susie again. I just want to say that I fully support going to the 5. I want to hear the discussion at the table between and the arguments, the pros and cons, like we hear at other committees. How many? You have 9. We just had the list up there of all the committees that have more members on it. I want to hear the discussion. And I've heard a couple people say that, well, we don't have a problem, why fix it if it's not broken? Well, okay, so it's not broken, but there's nothing wrong with saying, let's not improve it. Thank you.
Carol, are you waiting to speak, or?
I am.
Okay.
Carol Marple. Talking to the clerks in towns that have gone from 3 to 5 has actually changed my mind to being very much in favor of a 5-member selectman board. The clerks tell me that with 5, some of the advantages they have are people come out of the woodwork to run. There's something about being one of 3 that apparently must be intimidating. And with a 5-member board, there are more friendly contests. They also tell me that with that change, a single selectman cannot hold the board hostage to a particular schedule, that the Board of Selectmen is able to maintain the regular meeting schedule, and that the discussions become much more substantive, that there's a wider range of opinions expressed, and as Peter pointed out, they have to work a little harder to gain consensus, perhaps digging deeper, and making some really good compromises. So I very much am in favor of a 5-member board.
Thank you. Michael, are you waiting to speak on this?
So there was a request from hearing from people who are on larger boards, and so I do sit on one that has 6 people, and sometimes we convene in sessions of 16. So I think what's critical is if operationally the nitty-gritty truly has been moved out of the Board of Selectmen and into the town administrator's office, similar as it is from the education boards and into the central office, then this is a very workable idea, and I buy into all the merits. If they're still grinding away at a lot of the operational details that they do, I would find it hard to believe that there would be two more people who'd want to run and do that position. So that's just my perspective. I don't know what the answer is, but.
Peter?
Peter Black, 55 Maple Street. I kind of go with, if it's not broke, don't try to fix it. I think everything that's been said about a 5-member board, or rather about a 3-member board, that the potential negatives exist for a 5-member board. If it's political, then there can be 3 people that control the board. If it's political, 2 people can control the board, difference of 1 person. I think the Board of Selectmen don't support this, and they're the ones who are actually on the firing line. They're the ones who are holding the meetings and acting pursuant to the meetings. So seems to me it's working well the way it is, and I don't think going to 5 will necessarily make it any better. And it does invite other factions, if you will. So it's not a sure thing to make it better.
Any other comment from the floor? Okay, I'll bring the discussion up here.
Can I just say bravo to the government's committee for all 3 of these articles and the thoroughness and the hard work that you all did. It's really, just really well done. And as far as the article is concerned, just to address Peter's comment, I mean, when you say factions, I think we're talking about voices in the town. And for the primary policy board of our town, I'd like to see as many voices on that as possible. Not to take anything away from the fine work they do now, but the more people that participate, I think the better.
We have seen what a broken Board of Selectmen looks like, and it's not pretty. I'd suggest that you don't want to wait till it's broken to fix it. I have a specific question, though. You had like 150 towns had made the change, and that's in recent decades.
The Mass Municipal Association that Paul knows a lot more about than I do lists 55 larger cities have city councils. There are about 150 3-member boards. There are about 150 5-member boards. There's 1 7-member board of selectmen and 1 9-member board. When you look at them, there's a huge difference in the geographic split, as I mentioned earlier. Interestingly, as a historical tidbit, in the 1700s, the town of Sherborn had a 7-member board of selectmen, went to a 5-member board of selectmen for a while. Betsy's trying to help me out to figure it out. But in eastern Massachusetts, it runs either 2 to 1 or 3 to 1 in favor of 5-member boards.
All right. Well, let me get to the real meat of my question, which is, so towns have been moving from 3 to 5. Did you find any that moved from 5 to 3, or that moved to 5 and...
I did not. Did you, Ron? Kitty?
And so no one went, no one had...
Sherborn did in the 1800s. Yeah, I understand that. 7 to 5, yeah. I was interested in recent history.
Yeah.
And no one having made the change chose to go back and regretted their change, is it?
The enthusiasm amongst the towns that were on the first list, Southborough, Harvard, Sudbury, and Newbury. Newbury and Southborough have been thrilled with the change, including a TA in Southborough who was kind of against it, and he's just been thrilled with the results. But we talked to a lot of people. We did not do an exhaustive survey of...
No, I understand. I mean, I just wondered if somebody said, oh, we did that and
Yeah.
it was a disaster.
George, did you come up with anyone that fell in that category?
Carol?
Carol Marple. I put that question out on the ClerkNet, which reaches all 351 municipalities. And while not everybody responds to everything, I didn't get any responses from anywhere where they had gone back to a smaller number.
It's virtually impossible to go up to a smaller number. because when you have 5 sitting selectmen, you're essentially saying 2 have to go. That's a very hard thing to do. Going from 3 to 5, you're adding 2 who are not holding office, but removing people from office is a very hard choice. So those communities, including a number of my communities that went to 5, whether they like it or not, it really is not going back.
Okay. Right, Carol?
Just a response. When you have 5 selectmen, 2 out of 3 years, you're electing 2 selectmen. So if you were choosing to go backwards, you would do it, you would just do it in a year where 2 would not be renewed or reelected.
I see, okay. All right, so is there further comment up here? All right, I will take a motion to recommend favorable action on Article 16, increasing the Board of Selectmen from 3 to 5.
Please, 17, Article 17.
I'm sorry, that's correct. Article 17.
I so move.
Second?
Second.
All in favor? Opposed? Okay, unanimous.
Thank you.
Madam Chairman, may I just adjourn our committee now?
Well, before you do, Kitty, and before we move on to the next one, this committee was charged with, as a result of efforts last year, to come back to town meeting with their recommendations. And one of the efforts that was underway last year was to convert elected employee positions to appointed positions.
Yes.
I just wonder if they could speak to that, why they haven't brought anything forward, and what, if anything, they're thinking of planning to do.
Okay, great.
Thank you.
Yeah, I think you're not I think a lot of the town would like to hear about that.
I've just been informed that we have given an interim report to the town moderator, and we would like to continue, but our charge ends with the upcoming. It doesn't, I've been told it doesn't, research is being, I'll let George do it.
Let George do it. Where have I heard that before?
I never was happy with the name George, but I'm less happy now. It's my understanding that if the committee has not finished its work, which it has not, and it enters a interim or limited report, and it's accepted by the town meeting or the town moderator, the committee continues in existence until it issues a final report.
Okay.
But the explanation as to why you haven't approached that subject this time
Why we haven't
around.
approached the subject? We spent a lot of time on that, and there are a number of very significant issues, only one of which is the election versus appointment. There's also the combination of the two, and the role of the town administrator as a financial officer, and the possibility of creating a separate financial officer. All of those options should be considered before we make a recommendation, and that's what we would like to do.
Thank you.
Okay, thanks very much. Corey? Pardon me? Oh, sorry, Corey, you're so quiet. Bob says you want to speak?
No.
Oh.
Well, other than the fact that this sort of fell in my lap at town meeting. I remember someone asked the question from the floor, who's going to appoint them? And I said, that would be me. And it was kind of unexpected, but I was very gratified that I think 5 really quality people said yes and were willing to serve. And they had a tight deadline to get everything ready for the current town meeting, and I think they worked very diligently, having that short time frame, and did really good work. And I congratulate all of them, and I think it was a very collegial. I didn't attend your meetings, but I also didn't get any phone calls about how awful it was. So thank you.
We'll tell you the truth over a beer.
So moving on now to Article 18, that is to see if the town will vote to accept the provisions of general laws, Chapter 59, Section 5N, which authorizes the Board of Selectmen to establish a program to reduce property tax liability for veterans in exchange for volunteer services or take any other action related thereto. I will point out that Advisory Committee has received this last night, and we have had no opportunity to discuss it, investigate it, or anything else. So I'll just put that out there. Paul?
One of the fun things as a selectman is when you have a chance to make a difference. And this is an article that allows us to make a difference. This article is intended to address a national and state crises. As you all know, our nation has been at war for many years now. As a nation, we ask our citizens to put themselves into harm's way. And at the end of their service, they come home. And they've been coming home to a recession. The United States Department of Labor, the Bureau of Labor Statistics, reports that 29% of the veterans serving since 9/11/2001, report having service-connected disabilities when they come home. When they come home, they can't find employment. The Bureau of Labor Statistics again says that well above civilian unemployment rate for veterans. Despite training and job skills, vets encounter more difficulty in finding work than civilians. And as you can see from the newspaper, there is not only a high incidence of physical issues, there's also a high rate of suicide among veterans. This toll affects not only the vet, but also his and her family and the community. Yes, there are programs both at the nation level and at the Commonwealth level to provide support for veterans. But both the Congress of the United States and the Commonwealth of Massachusetts, the General Court, recognize that much more needs to be done for our vets. So the proposal here, Massachusetts has put together a local option program for cities and towns to accept. This program was well designed by a lot of lawyers attempting to address a whole set of legal issues, which I could go through. But essentially, it allows all the cities and towns to step up to address the situation for vets. It provides a tax abatement for real estate for up to $1,000 for a vet who's willing to volunteer 125 hours of time to a community. It allows the vet, if he's physically unable to work, to send a designated representative to do that volunteer work. It's well done because it's a tax abatement program, not a taxable income program. The article before you would authorize the Board of Selectmen to undertake and implement such a program. Let me address some of the concerns that people have. The first issue is, why is this so late in the process? This bill was enacted in 2012. It was signed by Deval on May 12, 2012. So it came way too late for the 2012 year and for our annual town meeting. In 2013, the town was in transition. We had a new town administrator that we were working on. We had a change in vet agents. Yes, it's late, so I apologize for that.
5 minutes.
Okay, can you wrap it up?
But this is a pressing need. This isn't about government budgets. It's about caring for people who need our help.
Okay, thank you. Is there a comment from the floor on this?
I could speak, and if I can jump in front of you, if that's all right, Mike. For me, I first learned of this just this past week, and Paul brought it forward, and I was torn between the concept of, sticking to policy and practice and, procedure, the process, and so forth. But also then, the other part of it was, here we have an opportunity to do something if we can do it. It's not material in terms of the budget and so forth, to the extent we do have to forego $1,000 per person of tax revenues, but in exchange we're getting work done that's likely to be necessary for $8 an hour. That seems like we make out financially overall. So for me, we voted 2-1 in support of this, and as I say, I was torn, and I fully respect my colleagues' other thought processes.
Sure, and I'll just tell you the reason I voted against adding this to the warrant. It was both procedural and substantive, mostly procedural. I think we had deadlines, and I think you're seeing the unfairness to you and to the public of having something introduced at the last minute. I also struggled with the fact that I tried to understand the senior tax credit by talking with town staff, and I'm not sure we even have a good handle on that. There's a state statute out there that we decided not to adopt a couple of years ago. It provides for minimum wage payments. We pay more than minimum wage under our existing program. So I had a lot of questions. It may well be that on further inspection, those questions could be answered to everybody's satisfaction, but I'm not comfortable with adding another tax credit program until we know that we're doing the right thing with the one we have.
Yeah, I would also ask, I've heard about a national crisis, I've heard about a state crisis. Do we have a town crisis? First of all, are there veterans in the town just, that we know of that are vastly in need of this? And second of all, if this was brought forth in the state in 2012, that's 2 years ago. So for whatever reason, it wasn't brought forth last year. It also wasn't brought forth early in the process this year, and in fact arrived. Some of the people that I sent the warrant out to early in the evening didn't get it because it came through later at night. So.
Well, I can shortcut that because I'm happy to pull this back and put it on a special that would address the issue that was raised and to extend that courtesy to the board. There is some urgency, and we do have the veterans agent here who I hope can give you some details about the vets in this town. But I do understand the argument that this is late in the process and you haven't had a chance to see it. I did it that way because there is a crisis and there is a need to help people.
In Sherborn?
In our town? In our town, there's a crisis?
The vet agent is over there.
Yes.
Would you like to address that?
Hi, Buck Brody, Curve Street. I'm the veterans agent. Just to put it into context for your consideration, there are 173 veterans currently that live here in town. And interestingly, of that 173, 145 are over 60 years old, 60 or over. So this is a program that would be obviously more geared to the elderly veterans that we have. I cannot make any kind of a representation of how many people would be involved in taking part of this. I can think of maybe 2 or 3 that might, but that's all. Now, Diane, on the seniors who are now getting this $10, Pat, how many were there total?
It'd be around 3.
That's how many?
3.
3 veterans that are on that. Am I correct? Mm-hmm. Yeah. And how many total that are now getting the $10?
11.
Yeah, okay. Of that, there are 3 veterans who are on that. So that just to put into context. It's difficult for me to stand here and make a really impassioned plea on this because it is fairly new. But I think it's something that should be considered and something that we could do for the veterans. But I don't think we're going to be overwhelmed with people who are going to be coming for it. First of all, the town has to want them, and secondly, they want to be working for the minimum wage.
Okay, thanks. Carol?
Carol Marple. I think this warrant article has an admirable goal, and I think it meets the criteria of doing no harm and perhaps doing some real good. I haven't heard anyone say that we have an immediate need just this moment, but perhaps we do and we don't know about it. Legislators call this kind of a bill a feel-good bill because people are loath to speak against it because it does have a good purpose. But again, I call procedure on this. And if this is something you really want for this year, I urge you to
Do what Paul just said.
to go the special town meeting route, and so that it can actually be done, the information out there, properly vetted, gets its own hearing, and I encourage you to vote no action on this.
Susie, are you hoping to speak?
Yes, I am. I was standing up, though. Hi, Susan Tyler again. I fully support the state law that came out, and apparently it was signed on May 12th of 2012. If it's been around and we couldn't do it in a town meeting in 2012, what happened to last year? And so I go to bed last night, 11:30, I printed off the warrant for this meeting. And we had an Article 18. I wake up this morning at 7 o'clock and look at it. It's not the same number 18. There's been no discussion on this. Why wasn't this discussed in June of 2012 or all last year? And where is the need? I fully support the veterans, but I think even the veterans would say there has to be a proper procedure followed.
Bob Delaney? Oh, you're ceding to George? Whatever.
I'll be quick. I'll use my time that I saved.
That doesn't work that way, George.
I just asked the veterans agent how many veterans we had in town. There's 173 of them. If you multiply that by 1,000, that's $173,000 off the tax rolls. While I'm in favor of providing assistance to the veterans, I think a little understanding as to what it means to the town to do this and where the selectmen who are urging this propose to get that $173,000 that we're talking about.
Can I answer that?
Thank you.
We have to work for it, George.
Sure,
That's okay.
if you're fast.
This, if you voted favorable action on this, and remember, I'm asking you to allow us to bring it back to you on a special town meeting to respect your procedures. But if you voted favorable action on this, this authorizes the Board of Selectmen to establish a program. And as part of establishing a program, we can say 10, 5, 15, we can put a cap on it. There are all kinds of things that you can do when you establish a program. Secondly, the funding for this is not like the senior tax program. The senior tax program, as you probably all know, has run into trouble with the Internal Revenue Service, and they're fining towns and they're issuing penalties and so on because they're income programs where people are getting employed. This is a tax abatement program. It's funded out of the overlay surplus. It grants an abatement on your real estate. The vet gets no cash at all. There isn't a check cut to the vet. The assessor takes an abatement application and reduces the tax by $1,000 or whatever the hours that are worked. So it comes out of the overlay surplus. So we're not looking for any money. It's designed to avoid the problems that have caused the Internal Revenue Service to put penalties and interest charges against municipalities who have these homegrown senior tax programs. Whatever the issues are with our senior tax program, that should not hold up a program for vets. They are separate.
Okay, thank you. Bob?
Bob Delaney, Pleasant Street. I think I qualify as one of those vets I served my overseas duty at Fort Niagara in upstate New York, and I suspect that a fair number of vets are in that category, because those that fought in the wars are probably at least as old as I am, which is pretty old. I also, if we're going to do this, I think there has to be an income cap for prospective bonuses, or whatever you call it, for the vets. If we don't have an income cap, I think it's kind of foolish. I mean, what are you going to hand out a credit, a tax credit to somebody who's making $100,000 a year or something like that, or has assets that make it totally unnecessary? And unless you have that, I will continue to speak against it.
That's the first
Peter?
thing in my mind.
Peter Black, 55 Maple Street. I'm one of the veterans, and I didn't serve in Fort Niagara. I served in Bintui. I think it's a good thing, but I can't imagine many people who live in Sherborn that are veterans or not that are going to be willing to work for 125 hours a year to get a $1,000 tax credit on their property tax. If there are such people, they would only be doing it if they really needed that. I don't think there are going to be many people that it would apply to. It certainly won't. I certainly won't do it. But that being said, as I understand what Paul's saying, the procedures would be worked out by the Board of Selectmen. Obviously, it would have to be administrated. There would have to be someone who would assign people tasks. And if we had 170 people putting in 125 hours a year, a lot of people are going to lose their jobs in Sherborn. So, I mean, I really don't think it's going to be a big issue. I think it's something that would work, and it probably would work much better in a bigger town with a lot of different income levels. I support it, but I think perhaps it ought to be flushed out a little bit more and be on next year's warrant so it's clearer. But I don't think we're going to lose any money as a town for it.
Okay. And if there's no further comment, and, Susie, something new, please.
It is new. I forgot it now.
Okay. I gotta remember that.
Thanks, you
Can I
scared
just-
it out of me.
Can I just respond to some of these comments?
Very quickly.
I want to reiterate that what's before you is whether or not the Board of Selectmen could be authorized to work on such a program. We need the authorization in order to do this. We're not going to try, at least I would not recommend to the board that we try a homegrown program like we did with the seniors, because again, the Internal Revenue Service has basically thrown those into a tornado of penalties and all kinds of unpleasantness. So the idea here is whether or not you would authorize the board to get to work on it. And let me make one final comment. I'm wanting to withdraw this article at this point as the primary sponsor so that I can bring it back to you and meet all your procedural requirements and the issues that were raised by the town clerk and by yourself, so that I would then request, let me withdraw it now, let me bring it back to you as a special.
I was just going to point out, it's on the warrant. It was voted by a majority of the Board of Selectmen to put it on the warrant. I think you have to vote no action at this point.
Right. Yes. Okay. Okay.
But when you vote no action, could you at least say at this point it's because it was withdrawn, not because you're
Sure.
against providing benefits to veterans?
Yes, I will say we're not against it. I won't also say that we're for it. I mean, because that commits people, if you understand what I'm saying. And I think you do.
Madam Chair,
Is there-
I'm for it.
Mary, I'd like to make one qualifying point, though, and I'm not the lawyer, but the part I don't like about this article, given that you may rephrase it for bringing it to a separate session, you say you're going to create a tax liability reduction for veterans in exchange for volunteer services, or take any other action related here too. I would take that last phrase out. I don't know what any other action related here to is, but that seems way too broad.
One thing I forgot to do is pass out what the actual statute is.
I've got it up.
You had this on the article.
Okay.
You know, my real quick comment, Mary, would be, I'd like to see the actual program and vote on it. I mean, I'm for it too, but just voting to establish it. I mean, the statute's pretty specific as to what you can and can't do. It is a maximum of $1,000. It is minimum wage credit on the volunteer, but
But you let
I'd like
know
to
if
see
we-
how you're going to do it
Yeah, I understand.
before I give it a thumbs up.
Is there any more comment up here? Okay, Ben?
I'm worried about this concept of a special town meeting just for this one item. Are there others that we've,
It will be within the town meeting. I
no,
understand.
but we've got,
Right.
we have to have another
Right.
hearing, we have to have another mailing, et cetera.
Well, you may have the HVAC thing for the fire department.
Right. So I am going to ask for a motion to recommend on Article 18, a motion for no action on this article, and I would say that I think there may be general support for the intent of the article, but the procedure hasn't, appropriate procedures perhaps have not been followed, and we are voting no action. So, if I
Voting
could
no
have-
action?
Well, that's the motion.
She's asking for a motion.
Just no action.
I'm asking for a motion for
Nothing.
no action. Can I get that
So
motion
moved.
from some, okay, a second?
Second.
Okay, all in favor? All right, there's a split here, 7-1.
Yes, in favor, you can.
Okay, is there anyone against? I'm sorry, okay.
He might have abstained.
Oh, he might have abstained, okay. Fine. So, 7 in favor, 1 against. All right. Okay, I'm going to take a 5-minute break here, because we're heading towards the end, and probably going to call a hard thing at 5 o'clock. 5 minutes.
Oh, you're not a lawyer. And why I'm not a lawyer.
What's your heart, Mary? Okay, welcome back. All right, we are up to Article 19, to see if the town will vote to accept the provisions of MGL Chapter 41, Section 38A, to change the title of tax collector to town collector, provided that the legislature approves a change in the language of the statute such that the words "shall collect" be replaced by less restrictive language, resulting in better defined flexibility in determining which funds are to be collected by the town collector or take any action relative thereto. And for our proponent, we have Nancy.
Okay, before you push the timing button, Peter tells me that I have to thank the Board of Selectmen for being here, so I want to do that first. But I do thank them for their support.
He's great.
Last year, I presented a similar article to change my title from tax collector to town collector. And at this hearing, concerns emerged as people tried to become familiar with the law cited in the article. I had had some of the same concerns when I first started, especially about the word shall and all, but had reached a level of comfort through conversations with the Department of Revenue and surveying the members of the Mass Collectors and Treasurers Association. I found that although different people interpreted this law differently, including the attorneys at the Department of Revenue, it seems that no Massachusetts city or town collector in practice follows this law literally and collects all the funds due their city or town. Several of our recent town administrators, including Mr. Williams, have asked me if I would be willing to receive funds other than taxes and their related charges. I have always said yes, but as a tax collector, I am prohibited by law from doing that. It requires a change in my title. When Jim Purcell was here, he wanted to put that very change on the warrant for a special town meeting. When the Department of Revenue did their review, they recommended that the tax office be the collection point for more of the town's funds. That recommendation was not a philosophical one regarding the government structure. It was about process and the town's funds and best practice, regardless of whether the town has combined, separate, appointed, or elected officials. It was a recommendation for which I could recognize a sound rationale. But it is a process that needs to be instituted in phases, so that what works is kept and what doesn't is discarded. It was suggested by the gentleman from the Department of Revenue that using the town meeting vote allows a greater flexibility for this than a bylaw or legislated change. But the law, as written, sends conflicting messages. And during an earlier break, I dropped a handout in front of each of you, and I'd like you to refer to that. I'm not going to go into great detail, but the very first page of that, at the top, is from the collector's manual, and it's Tax Collecting 101, tells you what I can do. And the second item on that page is an official legal opinion from the Department of Revenue that tells you what I can and cannot do. And then on the back of that page is another chapter from the manual that has an interesting use of the word must and may. If you specifically look at number 2 and then section 2, there's an interchange of the word may where the law says shall, which brings us to the last page, which is the actual law with the troubling language of shall and all. But if you continue on that same sentence, you'll see that they use may, define powers, and so forth and so on. And then the last section is the definition of, that's from Mass General Law, and the definition of a collector, which is actually the definition of a tax collector. So when I asked the Department of Revenue about the inconsistencies, especially in Mass General Law, Chapter 41, Section 38A, they said they recognized the confusion but would not be looking to enforce the detail of this law unless other irregularities existed. I suggested that they fix the law, and they indicated they would not be interested in such narrow legislation. So I asked if they would oppose someone else doing it, and they said the official response would be that they do not comment on legislation until it is before them. But the unofficial response was to go for it. And that is what I've been trying to do. Representative Linsky is working with the lobbyist from the Mass Collectors Treasurers Association to sponsor a change in the language to make it clearer that a town collector is not required to collect all the town's funds, but is authorized to collect any. And they are trying ways to expedite this change. They attached an amendment to the supplemental budget, and it passed the House without debate. But the Senate did not adopt the amendment, and though I submitted testimony, I just learned that it did not survive the conferencing. Representative Linsky and Senator Ross have filed a separate bill going forward and are exploring other avenues to get this done sooner rather than later. It has been suggested to me that the article be submitted to town meeting without the contingent language. And I would be comfortable functioning with that, but I recognize that it would be difficult to bring all the attorneys in the room to the same comfort level. I am willing to not handle funds for something that I am authorized to collect, especially since they're surrounded by a whole lot of gray area. But I am not willing to handle funds that I am clearly prohibited by law from collecting. I would like to help, but without this change, my hands are tied, and what I can do is now extremely limited. I would appreciate your support.
Thank you. So you are personally, you would like us to recommend favorable action on this? Is that your bottom line?
That's my bottom line.
Okay. Is there a comment?
The selectmen support this.
Okay. Any other comment?
Well, I need to clarify, Mary. It says, so it is, I'm not sure what we're supporting. It says, it has the words in it, provided that the legislature approves the change in language.
Right.
You want us to take that out?
So what does that mean?
Well, it means, provided that they do it, it looks like so far they have not done it, although if Linsky and Ross get another road in there, they might end up doing it. I mean, that's what I'm taking away from what you just said.
Right, because of the difficulty last year with the shall and the all, I'm feeling that there would be more problems with that if we didn't change the language before we accepted the statute. And my understanding is that we cannot vote a statute that's going to be fixed. We have to vote the existing statute, or not at all. So if the change doesn't happen, this will be a moot question at town meeting.
And do you expect resolution on that prior to town meeting, when we know when we go to town meeting?
I do not have any idea. It could be next week, or it could be the day after town meeting. I have no way of knowing that. It depends on how it falls within the legislature.
That's what I'm asking. I don't see what we're voting on. There's nothing to vote on.
So you can't change, you can't start collecting more stuff until the legislator acts, or you can on your own discretion if we take out that sort of precatory language?
Unless the town adopts this statute, I cannot take anything except taxes and the related charges. You don't like the statute the way it's written, so until it's changed by the legislature, and we were hoping that would happen before town meeting. That's why I'm looking for support, that if indeed the language is changed by town meeting, I have your support. If it isn't, it's a moot question, because we can't vote on something contingent on something that's going to happen.
I want to just make a lawyer's comment. I mean, we voted to support this, but a town can only accept a statute or reject the statute. You can't accept a statute with conditions. The conditions, everything after the acceptance is null and void. So the choice for the voters is, do you accept whatever's on the books, or do you not accept what's on the books? You cannot accept it provided that's not a legal motion.
But, okay, so I'm confused now. You're saying that we can only accept or reject what's on the books, and yet you're supporting Nancy's article? Is that correct?
Yes, because what she's saying is that it's going to get changed.
We don't know that.
We're hoping that it's going to get
We
changed.
don't know it's
Right,
going
and you
If
just
it
said
doesn't
the
get
vote
changed-
provided. Am I missing something?
At town meeting, the vote has to be to accept the statute that's on the books,
which is,
whatever it is.
Whatever the state says we...
So you want us to accept what's on the books now, and to the extent the legislature changes it, then your job will change sort of automatically.
No, I think she's going to withdraw it if it doesn't get passed.
Is that it? Nancy, do you want the town to accept the change, and do you want it to accept it even if the law isn't changed in anticipation it might be later in the year? Or will you stand up at town meeting and saying, sorry, they haven't changed it yet, forget it? Because that's two different paths.
That's right, and the path that I have chosen to take is to put this forward if the change is made. I would like the selectmen to embrace it and decide whether or not they feel it's worth, because it's been the selectmen's office who has asked me to collect other things. I would like them to say whether or not they want to put this out there without the contingent. I'm not going to fight that fight. Because of what I heard last year, and yes, there is a lot of differences of opinion as to whether or not it's legal to not collect every penny, which means that you'd have to have the senior citizens come and pay the collector before they could get their lunch and all that. Nobody does that in the state. They have found a level of comfort on defining what monies the collector should collect. But from the debate that went on here at the hearing last year, it was clear that people were really hung up on the word shall collect all funds. So I had reached a level of comfort to go forward with that last year because of my conversations with the Department of Revenue and how they're not concerned with this language. But I'm not going to try to sell that to the town of Sherborn if people are not comfortable with it. So my article says if it's changed by town meeting, then let's go forward. If the selectmen or somebody else wants to try to sell the idea without a contingency, I have no problem with that.
I was just going to say, what was presented to us as a Board of Selectmen is exactly what you see here. We did have that discussion with Nancy. I think some of us at least took a broader reading of the statute than she might have been. I understand her reading of the statute is informed by what she heard at this hearing last year from advisory, and so I think Nancy's trying to do the right thing for the town and for efficiency in government. I think the selectmen would support her. You heard we support this article. The difficult part is I think I agree that you can't have a contingent acceptance of a statute, so we're going to have to, before town meeting, figure out whether this article goes forward or not as an acceptance of the statute.
And so our vote, I guess that's the part that's confusing me. We, let's say, for argument's sake, that we all think this is a good idea in theory, that Nancy be called the collector instead of the tax collector. And I'm getting two messages here. I'm getting, we'd like you to support this, but you can't support anything with the word provided in it.
Well, right, and I think, I'm new to this, but what I saw this year has this strange request that it not be approved unless the legislation changes. My understanding is that was put in because of your board's comments last year, and that Nancy otherwise would be okay with accepting the statute if she was comfortable that she wasn't going to be put in jeopardy every time she decided whether to collect a particular item or not. She'd be more comfortable if the language changed. So maybe you've got two choices now, I guess, as I would see it. One is to vote in favor of this as it's worded, but only if the statute changes before town meeting. I guess the other would be to do the opposite. You vote it down, subject to being reopened if the legislation changes before town meeting. That seems to be a more logical way to do it from your standpoint. I don't know what the other selectmen feel. I personally wouldn't mind if you voted it without the proviso, because I think it's a good, it's a good thing for the town to have that kind of efficiency.
I think that last alternative is really the only alternative that makes sense here. We either vote just to change her name from tax collector to town collector, and then rely on a quote-unquote broader reading of the statute, which allows her to do that collection minus one or two little receipts and so we would be recommending favorable action, not on the language we have in front of us, but stopping that language after the word, I think, tax collector. And she says she's comfortable giving her inputs from the folks that everybody does it that way and no one really cares. That's what I heard.
The legal concern, again, I support the notion, the legal concern is that anybody can drop a dime. So it's not her comfort level, and it's not our comfort level. It's that we don't want her to get into trouble, and we don't want to spend legal fees on defending different readings of different statutes. So that was part of the problem here. We don't want her out on a limb. I mean, she wants to do the right thing by the community, but let's not leave her out there at the end of a limb and have someone else saw it off and have her get harmed.
Corey?
A general comment about, given my experience, how I think this is going to play at town meeting. I think Nancy is making a very subtle point, and she's trying to be sensitive to all kinds of concerns, and she's making a very subtle point. But we've now devoted, I don't know, 10 minutes to having a discussion amongst people who know more about what's going on in town probably than any other subset of people. And I think when this goes to town meeting, this is kind of doomed to be confusing. And I would urge you to look for the simplest solution always as a general policy. And I guess I do, there seems to be two, I guess if you have 3 lawyers, you can have 4 opinions. But, but we have 2 lawyers with slightly differing opinions about this. And I wondered what town council's opinion is on the simplest way to handle this.
Has anyone consulted town council on this?
Did she review this? I think this is her.
It's her wording.
I'm assuming it's been...
Yeah, it's town council's wording on that.
It is?
Okay. Well, I don't know. Do you feel that we'd have any additional information by the end of this hearing, whenever that might be?
And to be clear, I'm not offering any kind of legal advice. Mine was a policy comment, which is that we would support, or at least I would support, and I believe that the other selectmen agree, would support more efficiency in government and allowing Nancy to collect things beyond taxes.
Without obligating her to collect everything as the word shall implies, stipulates.
Without her being exposed to being dragged off.
Right, but what does, so
So Paul's not saying accept, the town's not accepting, at least, I got confused by what he described, okay? My understanding is not that we're asking the town to accept that statute unless the law changes, and that's really what we're dealing with here.
Yeah,
By the time we get to town meeting.
except that Paul, I think it was, said that
No, he's saying you can't accept the statute with a
With
proviso.
At town meeting.
We're asking for planning to accept that statute unless this shall go, if it doesn't go away, you're not going to be asked to do that. I'm probably not helping you much, I guess. I wanted to be a lawyer, I guess. I should have been a
But
lawyer.
I'm going to agree with him. What I was talking about was the vote at town meeting. Town meeting has to be up or down.
Right.
But your vote can have all of this, that you are planning, I think this is what he's saying, that you are planning to recommend approval
Subject to
if she can do it safely, and if she can't, then you won't.
And is that stopping the article after the word town collector, or is that including provided the legislature, yada, yada?
You probably ought to conclude the whole thing.
I
And we
just don't
can't
think this is
vote on
ready for prime time, Mary. I don't think this
And we can't
proposal is
I'm
baked.
confused. I'm horribly confused.
Why not, I mean, I'm going to go back to what Jeff said, and that's probably all I should say. She's comfortable that they are not going to require her to collect every single thing on the town. I guess the dime, you, to borrow your phrase, you're worried about being dropped is that she doesn't collect a farm pond sticker fee or something. Someone's going to call the Attorney General and say she's not doing her job properly?
That's the
I mean, you
danger
know,
of public, volunteering for the public. It's always somebody who can do that.
I mean, if she's comfortable doing it, and what she's heard is that they don't enforce it that way, I'm perfectly comfortable just putting a period after the word town collector and getting this thing moved.
Elliot?
I don't particularly like the name town collector. I'm old-fashioned, it's always been tax collector. Seems though the town collector should be driving a trash truck.
Unfortunately, that's the legal term.
Okay, well,
Nancy, are you comfortable collecting 98% and not collecting the 2% that someone will do otherwise?
I am comfortable phasing in other collections other than taxes. And what's collected, I would hope would be determined through a collaborative effort with the town
That's right.
administrator and the departments. And I am comfortable, yes, not collecting something I'm authorized to collect, but I'm not comfortable collecting something that I'm legally prohibited.
Okay, but I'm going to try this one more time. You collect
Under the
you
town
collect
collector,
taxes, okay, that you're comfortable with. If we call you collector, not
Town
tax
collector,
town
yes.
collector, are you comfortable collecting everything except for some 1 or 2 or 3 items? So not all of it, but most of it. Are you comfortable?
Well, I'm not sure whether most should be in there. I'm comfortable collecting other things under the title of town collector.
Okay, but but the key question that we're debating here, but you would be comfortable if, while collecting other things other than tax, you didn't collect all of the other
Yes.
things. If you are comfortable with that, and we don't want to force you to do anything you're uncomfortable with, if you're comfortable with that, then we should recommend favorable action on this bill, leaving out the proviso language after the word collector.
So
And
simply
that
stopping
solves
with
the
word
problem.
town collector.
And then you will get the authority, it will be approved at town meeting, okay? And no one at town meeting, as Corey says, is going to care, because they're not going to understand this, it's an efficiency. It will be approved, and then you have the various, and no one's going to come and get you, I don't think.
So are you comfortable that the town bears the legal liability, the risk, however remote? Maybe you can sit there and say, I can predict that the risk is nominal, or I know I can't, but that she's not collecting everything this law requires her to collect as a town collector.
If you read the rest of the law, it says that you may define, I forget exactly how, but it allows you to define the powers within that. So that's what the rest of the states hanging their hats on when they don't collect everything. They allow, yeah.
So may does not mean must.
Well, I don't have that in front of me. I know we did see it earlier. We saw it earlier.
So I might have a suggestion for how your motion is so that it incorporates that words if you're going to go down that route.
And so you are not comfortable with us stopping simply at the words tax collector? Town collector. To see if the town will vote to accept the provisions of MGL Chapter 41, Section 38A to change the title of the tax collector to town collector. End of story. And you are, I think what I'm hearing from you now is that by doing that, we are still within the, I guess you'd call it the 4 corners of the law, where the law says that you may, but not must, and that these gentlemen are the people who define what they would like you to collect.
I don't want to be in a position of interpreting the law on the fly, and especially since this is interpreted by many different people, many different ways. I am comfortable if you want to stop there and remove the language.
So when we voted in support of that, it was what we were reading here. So I personally, I respect my colleagues. I would not be comfortable because I don't have it in front of me, and I'm not good at interpreting the law, and I think there are exposures that I can't measure, so I would not be comfortable with the change that you're suggesting. So I would withdraw my support in that situation.
Carol?
Carol Marple, as a public official, I really urge you not to put a public official in this position. Nancy said she's willing to be in that position, but trust me, when the judge looks down his long nose at you, you don't want to be in that seat. And I think we should take the time to get it right.
I would say maybe we should go for no action and wait till this thing gets clarified.
All right, that people are, okay, so I will accept a motion on Article 19 to recommend no action on this. Do I have that motion?
I so motion.
Second? All right, all in favor?
Good luck, whatever you are.
Article 20. To see if the town will vote to close public town offices on Saturdays in accordance with the provisions of Section 110A of Chapter 41 of the General Laws, or take any other action related thereto. Carol?
Carol said what I wanted to say, but she said it much better than
Okay, so first of all, to answer the question that I've had from several people, adoption of this does not mean that public meetings are prohibited on Saturday. Lay that to rest. Most towns, in fact, I was very surprised when I went to invoke this particular statute that we hadn't accepted it before. It was something I'd never looked at. This would allow any town department, when the last day to act on something falls on a Saturday, to move it to the next succeeding business day. And the example I would use is that one of the special elections we had this year, the last day to register to vote fell on a Saturday. So I was obliged to have staff from 9 o'clock in the morning till 8 p.m. at night at the expense of the town for no one to come and register. So this would eliminate those kind of expenses.
Comments?
Selectmen supported this.
Any comments, questions up here?
Does this mean that the town could not otherwise, if you had some other reason to open a town office on a Saturday, you could?
You could still do so.
Okay.
I think it's just that if it's closed, that's treated as a legal holiday and whatever sort of due pushes to the fund.
For that
Legal
purpose.
day.
Yeah.
Okay, so I will take a motion to recommend favorable action on Article 20.
Moved.
Second?
Second.
All in favor?
Thank you.
Article 21, to see if the town will vote to amend its general bylaws, Chapter 16, Section 2, Paragraph 3, by deleting $25 under the unlicensed dogs penalty and substituting therefore $50.
This sounds like a great revenue stream, but in fact, it's already in state statute. Last year, the legislature passed a new animal control law, and one of the teeny little sections that nobody paid any attention to was this penalty shall be not less than $50. So this will bring our bylaws into compliance with state statute.
Any comment from the floor?
Selectmen supported this one.
Okay. Any comment up here?
Yes. We've had some concerns on other articles about duplication and redundancy with state laws. And I would wonder why, instead of putting in any specific number, we just say as specified by MGL blah, blah, blah.
Well, I think putting the actual amount in there, because it's not likely to change for many, many, many years, provides transparency to our residents.
There's another reason. If there's a statute that allows for non-criminal ticketing for enforcement of local bylaws, so she can issue a ticket for it, whereas if you simply refer to the state law, then you've got to use the state law remedy, which probably is filing a criminal complaint somewhere, which means she has to go to court and do all of that. It's much easier to write out a ticket.
Any other?
Just keeping up with inflation.
Okay, so I will take a motion to recommend favorable action on Article 21. Second?
Second.
All in favor?
Thank you.
Unanimous by all
Thank you,
present.
gentlemen.
Okay, Article 22. This is an article by the Agricultural Advisory Committee to add a second sentence to the first paragraph, so that the first paragraph now reads extensively, or take any other action related thereto. And the proponent for that, I guess, is John?
Yep. When the Agricultural Commission was first, bylaw was first proposed, I believe that was 2010. On town meeting, the advisory committee had recommended no action be taken. On town meeting floor, that recommendation was rejected, and there was an amendment made to the Agricultural Commission that was voted on. The second sentence was removed. That sentence is actually the heart and the soul of the Agricultural Commission. And that sentence, and it's actually almost a paragraph, so it was a little bit confusing when people talked about sentence versus. But what was removed, the Commission's duties shall include, but are not limited to, the following: serve as facultators for encouraging the pursuit of agriculture in Sherborn, promote agricultural-based economic opportunities in the town, act as mediators, advocates, and educators, and/or negotiators on farming issues, work for preservation of prime agricultural land, advise the Board of Selectmen, Planning Board, Zoning Board of Appeals, Conservation Commission, Board of Health, Historical Commission, Board of Assessors, and the Open Space Committee, or any other appropriate town boards on issues involving agriculture, and shall pursue all initiatives appropriate to creating a sustainable agricultural community. That's what we'd like to have put into the charge of the Agricultural Commission.
Are there comments from the floor?
After a bit of discussion, the selectmen support this article.
If I could, just to add to what Jonathan said, I was one of the proponents of the creation of the Agricultural Commission, and we were on the floor of town meeting. The reason why we took the sentence out that he now wants to put back in was because there was a reference to all these boards and committees.
Yeah, I wondered about that.
And as I raised earlier in connection with the prior article, no one had gone around to all those boards and committees and talked to them. So there was a barrage of questions coming up. I mean, what does this mean? What's our role? Why are we mentioned? Why weren't we consulted? There was a negative recommendation from advisory in part on that basis that there hadn't been the homework done. So we took that sentence out at that time. Now it's been 2 years or 3 years. The commission has been operating successfully. Everybody now is familiar with it, so I don't think there's the same concern amongst all these boards and committees. The original sentence came from a form supplied by the state, I think it was the Department of Agriculture, provided the model that we were using. So our language now is the state model, except this sentence, and this sentence would restore it back to the model that the state had put together.
Okay, and I have a couple of questions, I guess, for John, and maybe you guys can address them as well. When I read this, a couple of things that struck me were the phrase, "but are not limited to the following." So, are there any limits to what these folks can do? I mean, I say that sort of humorously, but also not so humorously. So are not limited to, it doesn't seem to state that, where the line is drawn on what the commission cannot do. And also, to the issue with, I have an issue with, or perhaps I do, with act as mediators, act as negotiators. What does that mean? To me, mediators and negotiators seem to be rather legalistic terms. Maybe they are not, but I just like an explanation of that. And I also have some question, sort of having been educated to the nuances of shall and may from Nancy, in the last line there, where it says, on issues involving agriculture, and shall pursue all initiatives appropriate to creating a sustainable agricultural community, and so you've got to do it. So those are questions that I have, and I'm, willing to be educated.
I can address the first question. The name of this commission is Advisory Commission, Agricultural Advisory Commission. And throughout the whole bylaw, when you look at it as a whole, it is plain, they are advisors. They have no power other than to advise. And that's the whole purpose, and that's the thrust, and saying that their duties include but are not limited to was only intended to say that the list here of things that they were advising people on is not limited to what the Department of Agricultural Resources thought of at the time they put the draft together. If there are other places that they can be advisors, they should be free to step forward. On the issue of shall, the suggestion was made by Peter Caruso, which I think is a good one, is to change all the shalls to may, so that it's clear that it's permissive, because we don't want them to feel they're required to jump into a phrase. So if that's acceptable,
I think that's acceptable. I mean, the shall and the may can always be a little intimidating.
So if we change the shalls to may, then I think we would address both the issues you raised.
There are other comments?
Well, the other part, talk about the mediation and negotiators. Some of that is that we have, through the state organization of Massachusetts Ag Commissions, that they have just recently entered into a partnership with UMass Boston for mediation services, so that we could bring out someone to help mediate a problem that way. Mediation, in my mind, and I've had a little bit of a lesson this year through my school board committee, a mediator comes out there and tries to mediate the situation, but it's non-binding, it's you hope you can come to an understanding of both parties and to an agreement. Same thing with the negotiation. You're trying to negotiate to resolve the problem. But we've joined the Massachusetts Association of Agricultural Commissions. They're a great resource. There's a lot of people, the Farm Ag Resources have people involved with it also.
Great. I actually, we'll vote this, and then I want to make a little statement.
So I had a conversation with town council just because I was concerned, or I wanted to be sure this wasn't creating additional rights or duties of the Ag Commission or obligations of these other groups to have to utilize them in permitting and all that sort of thing. And the answer was no, it really is, it helps further clarify the resource that this advisory commission can serve, doesn't necessarily have to.
Okay. Is there any other?
Can I ask a question? What is this thing? Is this in the bylaws? Because I see...
Yeah, there's more to it in the town's bylaws.
Where is it in the bylaws? I couldn't find it. And I do see this exact mission statement on the town website under Agricultural Commission mission statement. So I just don't, I was trying to put this in context and I couldn't figure it out. Yeah, I'm not opposed to it, and I like the change you're talking about, but just so I know where this thing lives.
I thought I understood that the paragraph is removed, only the commission was created. This is an act
second sentence.
We can't hear him. We can't hear him.
I'm sorry, Grace, if you're going to speak.
No, if I understood Russ's question, he's looking for something that isn't there. Last year, wherever it happened, all that happened is the first sentence was accepted, so the commission was created,
Right.
but the rest of it isn't there.
Right.
You're being asked to put the rest there now.
Yes.
Okay, but on the town website, the rest is there, except I don't find it anywhere in the bylaws, so that was
It
my
wasn't
confusion.
I think he's saying he can't even find the first sentence in the bylaws. Is that correct?
It's not a bylaw, it was a vote at town meeting. It was a town meeting created committee. There are three
Okay.
ways committees can
Okay.
be created. One is by bylaw, one is by the Board of Selectmen, and the third is the town meeting, just like the Governance Study Committee. You won't find a bylaw on the Governance Study Committee. Town meeting can create a committee.
So is this similar to like Farm Pond Committee without a budget?
That's a selectman
Oh,
committee.
okay.
No, okay, that helps, because I get what you're saying, and like I said, this charge already appears on the town website. I think it's good to change it to a may for everybody's comfort level, but other than that, it's great, go for it.
Okay. So if there's no further comment up here, I will take a motion to recommend. You're all set? Everybody? Yeah? Okay, okay. I'll take a motion to accept favorable action on Article 23 with shall and must, if it's in there, change to
It's
may.
Article 22.
I'm sorry, Article 22, with shall change to must, wait, hold it.
Shall
May,
change to may.
shall change to may,
In two places.
in the instances
So moved.
where it appears. And a second, all in favor? Okay, unanimous by all present. Okay, Article 23, and we will not read through this, but this is to see if the town will vote to amend the general bylaws by adding a new bylaw, Chapter 28, Right to Farm bylaw. John?
All right, the right to farm bylaw, the purpose and intent of the right to farm bylaws is just to state with emphasis the right to farm according to all citizens of the Commonwealth under Article 97 of the Constitution and all state statutes and regulations, including but not limited to Mass General Laws, Chapter 40A, Section 3, Paragraph 1, Chapter 90, Section 9, Chapter 111, Section 125A, and Chapter 128, Section 1A. This bylaw encourages the pursuit of agriculture and promotes agriculture-based economic opportunities and protects farmland within the town by allowing agriculture use and related activities to function with a minimum conflict of others in towns. This, again, has come out of the Mass Department of Ag Resources. Currently, there's 136 communities, 136? No, the right farm. 136 communities that have adopted wording similar to this. There are some minor changes. With our meetings with the Board of Selectmen, Planning Board, and Advisory, we have made some minor adjustment to the article. This is not creating anything, any special rights to Sherborn Fire. We're not Sherborn Farmer. What we're trying to do is to put the laws down at the local level so people can see them. People can go to the town site and reference these laws and look at the state statutes and stuff like that. We're not creating any new laws. We're not passing any sort of special rights for Sherborn farmers versus anyone else in the state. This is, as I said, this puts it down to the local level. It helps people have a better understanding of the farming issues and the laws that pertain to farming, and hopefully with the Agriculture Commission hand in hand, help resolve issues before they get too big and start costing the town money. As I said, again, this isn't anything special. It doesn't allow me, being in the town of Sherborn, anything differently than what I'm currently already doing, but it also tells people what section of laws that I'm kind of operating under and the allowed uses. So.
Comments from the audience?
Sure. The Board of Selectmen voted 2-0 to take no action on this, and Paul abstained because of his farming interests. it was a little bit of a struggle in thinking about this because we do want to support farming. It's a very important industry for the town and a way of life and a productive use of the land in town. We thought this, in some ways, creates, even if it's not intended to create new rights, in fact, it creates the perception of new rights. It may, in fact, tilt things in a way that would favor farming, even in a circumstance where farming might not be the best or the prevailing side of the dispute otherwise. And that's not to say that there aren't a lot of times when the farming interest should prevail, but there may be times when they shouldn't. This is, it just, unfortunately, it goes too far. I do appreciate, and I think we do as a board, that they did make some changes, and one of the suggestions someone had made was that Holliston has a recital of the state statutes, and that's the way they address this. And I noticed they put that in Section 1, but then there are still other provisions in here that try to restate the rights.
When we heard it, it was more or less stated to us that this kind of restates the state law, and I think in general, the feeling has been that we don't want to restate state law as local law, because then if there's a change in the state, then we have to go around and change the local law. And, I mean, advisory has gone that way, and I realize we just voted differently from that on the dog licenses, but that's a very specific number, so. Is there other further comment in the audience?
Yeah,
I know there is, Susie.
Of course there is. Susan Taylor, I'm a member of the Agricultural Commission, and I just want to say, if you take back some of the comments that were just made on the previous article, one of them said the reason to approve the charge of the Ag Commission was to further clarify. Well, this is what the Right to Farm bylaw is doing. It further clarifies for the townspeople, for all the different boards and committees in town, and we all know there's many, and they all have their own opinions. But this clarifies in one place, not only for the residents, but also for the boards and committees, as to how a agricultural commodity in town has to operate. Thank you.
Thank you.
And I think the board was generally accepting of the idea that we might want to have some type of a pro-farming language, but this, for example, sets up a dispute resolution process which involves town boards, and it does state in Section 3 sort of fundamental rights and issues related to farming in a way that's not derived from a state statute. So we would be presumably making new law in that respect, and for that reason, I think it goes a little too far.
Yeah, I feel that there's a difference in degree here between, this is a law, and the previous article is sort of a feel-good charge of go do nice things, so.
Michael Less of Forest Street. I like the idea of supporting agriculture in town. I'm not sure how I feel about this thing, except for the idea that somehow I also want a group that promotes not just normally accepted practices or generally accepted practice, but that in our context we actually want good practice or better practice, that there's a reason for the environment we have now and how we live now that I'm not quite sure where the line is between what's general and good and what would I consider to be practices I want next door. But I would like to have agriculture, so I'm a little torn on that.
Okay, is there a comment up here?
Well, I'm a little torn too. On the one hand, it says that, allowable or incidental noise, odors, dust, and fumes associated with normally accepted agricultural practices. And then it says the benefits and protections of this bylaw are intended to apply exclusively for farming, blah, 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 but intended to apply with generally accepted agricultural practices, federal and state laws, and local bylaws. Well, our bylaws sort of limit incidental noise, odors, dust, and fumes. So on the one hand, we're allowing those things. On the other hand, we're sort of regulating those things. It seems to me a built-in contradiction on that Right to Farm declaration.
And we have a state law that we can fall back on. Any other comments up here?
Yeah, I would second Michael Lesser's point about good and normal. In some places, it's totally normal to have a factory hog farm, and that would be a total horror show. Not that I would expect one to be coming here, but
Oh, I didn't tell you.
yeah. It's what's going in at 90 Maple Street, I understand.
Ooh, too soon.
Too soon.
I would suggest that the commission just take the state law and put it under your charge. And, you know, Massachusetts general law provides that there's a right to farm, and just recite it out so it's right there for the town, which I think would accomplish what you're trying to do anyway, is to get it in front of people's faces.
Yeah, I talked to Susie the other day about, you know, now that the town has this website and there is a web page for every committee and group and so forth, and I am very much pro-agriculture in Sherborn. And, you know, one of the reasons we moved here are the beautiful apple orchards and the country fair, you know, all that. So I like to see more of that, but I'd like to see it on the web page and not writing new law into it, so. All right, if there's no further discussion, I will take a motion to recommend no action on Article 23.
So moved.
Second?
Second.
All in favor? Okay. Okay, Article 24.
I'm already up.
All right,
Can I just
to
go with the
see,
sponsor?
all right, to see if the town will vote to amend Chapter 17, General Wetlands Bylaw, Section 2, hearing of the general bylaws by removing the following language from the end of the last sentence in the first paragraph, and by mailing a notice to the applicant, the Board of Health, the Board of Selectmen, the Planning Board, all abutters, and to such persons as the commission may by regulation determine, or take any other action related thereto. Michael?
I guess we'll have a little fun with this one, too. This is, we might have misspoke before when we were before the selectmen with this change. The wording here that we're trying to change, most of it is in the state act, except for the words Board of Selectmen and all abutters. Our change is bigger than just taking out those 1, 2, 3, whatever, 7 words, and taking out a whole phrase. It's part of this whole issue that we struggle with continually of, we have a bylaw that reproduces some of the state act, but not all of the state act. It's that whole balance, as you talked before, of how much do you repeat the stuff from the state? We have to have a bylaw that's more stringent than the state, but you often end up repeating parts of it. Part of it is also the fact that if the state law ever changes, and you have it on the books there, then you actually have to then go back and amend it. So we erred, it's gone through town council, we erred on the side of taking out a little bit more, and taking out the whole phrase, even though most of that phrase is in the state act, and we still have to do some of that anyway. But, and it's stuff that the commission has to deal with, so that it's not issues that, as if an applicant should know, oh geez, I have to go to the state and not here. This is something the commission knows about. And so we've gone further and taken out the whole phrase, rather than just the 7 words. You can achieve the same effect the other way, but at least this way there's a little less duplication, but some people would say that you need to have more of the state. You'll hear about that difference of opinion. But, so we're going to just, we want to go remove the whole phrase, even though a lot of it's at the state level, just in case that ever changes. And it keeps the most important part of saying when things are notified. And the issue of dealing with abutters and whatever is dealt with previously. And it's not actually in the state act, the abutters wording in this phrase. And that's well addressed in a previous part of it. So in the end, it still does reduce some burden, and we're not doing anything that the state doesn't do.
Okay, I'm
sorry,
confused.
I know.
Because last year, I thought we dealt with this where the whole thrust of last year's
Yes.
law was to bring us into
We
conformance.
missed, this was an oversight that these, at least including the selectmen and the abutters, was a mistake that we missed last year. That's what started
So this
this.
is to totally bring us into conformance with the state law?
No.
No.
It is, well, it drops some of the language that's in the, yes, we will be in conformance with the state because we cannot be less stringent than the state. So we have to follow the state act no matter what.
Okay.
We're taking it out of our town bylaw. There's a few words here that are beyond the state that we don't need. We're taking out, plus we're taking out wording that is also in the state act, but it's simpler for us. And if the state act ever changed, we wouldn't have to change this again. And so, but we're always struggling with the fact that, sure, the first part of the phrase is in the state too. And so why do we keep that as opposed to refer everything back to the state? So we're always struggling with that balance. But with the change in place, we're in conformity with the state. And we're getting rid of the two egregious errors, which not the egregious, but the two big of getting rid of the fact that about notification of abutters, which is dealt with elsewhere, and addressing the Board of Selectmen, which the state does not ask us to do. And in the future, we generally communicate with the others, the Board of Health and the other selectmen. We have to send them stuff anyway. I'm sorry if I'm not wording this so tersely or clearly. But we're not lessening what we have to do in terms of what the state requires us to do. We're meeting the state requirements with this change in place.
Are you doing more?
No. It's going back to the state level because we're deleting language that goes beyond the state.
Okay, so that's,
That's our main part of it.
okay. Mike?
I was say, Board of Selectmen voted 3-0 to approve this based on the idea of trying to reduce regulation and unnecessary costs on applicants. But I do have a question that was raised by Michael's comments, which is, are there circumstances in which an applicant would only be coming in under the local bylaw, for example, jurisdictional area that we only cover under the local bylaw? And in that case, would there be a butter notice or not? It looks like probably not.
No, there would be one in the previous paragraph at the end of
So
section
so
one.
it's just a separate section where there's an abutter notice paragraph?
It's
Okay.
not for an RDA.
What?
He's asking in the preview for an RDA. Is there a butter notification in an RDA? No, there's not.
No, there is, no, but for the notices, what he's referring, the notice that's referred to here is only for notices of intent. The state, that's what the state requires all the abutters to be noticed, and that's what we do too.
Right, and that's the notice of the filing of the intent, but not the notice of the hearing. And I guess the question is, in a circumstance where DEP would require you to notify of a hearing date, are you requiring applicants who only come in under the local bylaw to notify of a hearing date?
Actually, the state doesn't require you to, it's an interesting when you read, the state does not require you to tell all the abutters of the actual date of the hearing. It's only the fact that it's been filed. And when you go through the State Act and the state regulations, you're actually not, it's the notification in the paper that they're supposed to see, that you don't have to actually say, you're not actually required to notify the abutters of the exact date of the hearing. And that's
Okay, so
not
it
at the
still
state.
would not be notifying the
Right,
abutters of the
exactly,
date of the
right,
hearing.
yeah. It's not, that doesn't exist at the state either, which I thought was interesting, that.
Susie?
Yeah, hi, Susan Tyler. I just last night watched the January 16th meeting where the Conservation Commission came before the Board of Selectmen. And I watched it because there was something amiss for me. And I rewatched it, and the way that this Article 23 was presented to the Board of Selectmen was it article that Section 2 of the bylaw was redundant, and I'm quoting there, the language is redundant to the notice. Section 1 of the bylaw deals with filing the application of the notice of intent. So that's what goes out to the abutters. If they happen to know when a hearing date's going to be, which is very unlikely at that point, that would be included. But so that's just the notice. Section 1 was the notice for the application. Hey, everybody, I'm filing for plans. Section 2 that's talked about here deals with the hearing notice. And by eliminating the mailing, the wording you all have it there, mailing a notice to the applicant, the Board of Health. State law clearly states the Conservation Commission, I'm reading the state law, the Conservation Commission, selectman or mayor receiving notice under this section, and again, this is for a hearing, shall hold a public hearing on the proposed activity. Notice of the time and place of said hearing shall be given by the hearing authority, Conservation Commission, at the expense of the applicant, not less than 5 days prior, by publication in a newspaper, and then it says, and by mailing a notice to the applicant, to the Board of Health, and the Planning Board. That's the Conservation notifying the applicant, the Board of Health, the Planning Board, when that hearing is going to take place. It's going to be in the newspaper. Hopefully, the abutter that received the filing 21 days earlier is paying attention. They can also call the Conservation Commission and say, I want to be notified when that is. So there's two different things here. And what is redundant, or not redundant, what's not necessary per the state is, they do not need to notify the Board of Selectmen or the abutters of the hearing notice, not the filing. So there's two different things. One's the application, one's the hearing.
Susie, what statute is that? What's chapter and
Well, that's
section?
Mass General Law 131, Section 40. And it's about the 7th paragraph down into it.
Thank you.
You're welcome.
We would follow the state law act that has the wording. We're just not reproducing all of that wording in our bylaw, is what it comes
Yeah,
back
but when you,
And there's lots of cases of this. It's throughout the whole thing, that trade-off of how much do you reproduce the state law when it might change, even though it's unlikely.
I just have a simple question. Is it of interest to the abutters to be notified? Is there something being lost here? I don't understand most of your laws, so I won't pretend to. But is it to the interest of the abutters at this hearing to be notified not only of the intent of it happening, but of the actual date when it's going to occur? And I'm asking you that because I applaud efficiency in cutting down costs, and I realize that the state doesn't require the abutters to be notified at that level. But if they're used to it in this town, and you've done it in the past, and it actually has a function, maybe we would like it. So just don't talk about the rest of it, just is it useful?
I would say, I don't know whether I can admit, I don't think we, I don't know whether I should, I have to say, I'm not sure we actually, a lot of some of these notifications aren't followed in general. If you talk to the DEP, that the abutters, there is no formal mechanism. We have not been notifying abutters by a separate mailing. I don't think it's ever been done, probably, and it's a... Right, and so nothing's lost because it hasn't been done, and we haven't even, it hasn't ever been done, and it's when you talk to the state about a lot of notifications of different boards, they will say, it's a little like when Nancy was here, they do not, nobody does all of the level of notification that they have in their act and regulations, and they recognize, and they say that they do not, and they won't change it. So it hasn't been done. So it hasn't been a problem historically, even though I don't know if somebody's complained about not knowing something.
Okay, Carol?
Carol Marple, I'm appalled to hear
I
that.
can understand it. I understand it. I don't know whether I'm going to be carted away or something like that.
I'm just appalled. But it seems to me when the mantra of municipal government is transparency and accountability, and we're actually changing our bylaws to eliminate some of that, it would seem to me that it would be certainly in the interest of abutters, but also in the interest of getting everything out in the open at your hearing, that you would want to notify those abutters.
We get the abutters, and people are notified. I don't think it's not a lack of transparency, because they know that it's all there. We check to make sure that they've all been notified that it's happening. And it has not...
I thought you just said you don't.
No, because they know that there is a filing. They are not notified of the exact date, but they get...
Precisely.
They get a notification that there will be a public hearing. They don't know when it is, because they know that the paper has been filed. We can go through and do that. It's an expense that we can change our practice to do
Sometimes
that.
good government costs money.
I have no problem with that, and it's a matter of taking a lot of the time of our staff and the others to do that. And,
I urge you to
and it's
vote
a
this
practice
down.
that hasn't. It's a practice that I don't know we had any problems with it.
Can I make a comment here?
Sure, Bob.
As a lawyer and as a selectman,
How about your trouble?
obey the law.
Fine. Okay.
The law says you have to give notice to abutters. Please, obey the law.
State law doesn't say that.
The state. It's all right. It's in our bylaw. Even the state doesn't say it. That's what we're trying to change.
Until it's changed, then please comply with the law.
Okay.
Okay, one more, Susie. Make it fast.
I just want to say, again, it's the notification of an abutter is under our bylaw, Section 1. What is proposed here to change is Section 2, which is the hearing. State law does not require the abutters to be notified of the hearing, but it does require the Conservation Commission to mail a notice to the applicant, to the Board of Health, and the Planning Board. That's in the state law, that the Conservation Commission has to do that. So to remove all the language is removing some of the stuff that the state is saying has to be done.
Okay. All right.
Thank you.
If there's no more comment here, I'm going to take a motion to recommend no action on Article 24.
So moved.
Second?
Second.
All in favor? All right, Article 25. Okay, this is, without reading this entire thing, it's quite lengthy. This is the marijuana zoning bylaw, and I think we have the marijuana zoning bylaw people to talk to us. It's Gino and John Higley.
This will be the high note of tonight's.
Nobody gets anything if we start with a joke.
I'm glad you said that, not me.
Okay, John.
Okay,
Good.
Article 25 is the medical marijuana, and last year we adopted a moratorium on the registered marijuana dispensaries, in part to see how the new state law was going to be implemented. The state specified the Board of Health would develop the implementation they have. That limits the number of these registered marijuana dispensaries to 5 per county. The applications came in, 180 applications initially came in, that was reduced to 100, and then 20 were awarded. There likely will be more in June. There should be, it's expected there would be about 30, there would be 35 of them by the end of the year. As expected, the ones that were awarded and really the applications are all for large market areas or areas that can't be reached by other markets. It's very, very unlikely any would ever be located in Sherborn or towns like Sherborn. But if we don't adopt something, the moratorium expires this year. If we don't adopt something, then they could be located anywhere in town. So to enable the Sherborn to have some control, we've developed this article. And the bylaw language is really taken from other towns. So we have looked and seen what other towns are doing. From MAPC, Metropolitan Area Planning Council, advice from our town council, and we've discussed this at a planning board hearing. The specific features are that it's specified that it's any siting would be 500 feet from a school, playground, or athletic field, and that's from the parcel. That it's in, we specified business general district because we treat it like another business. It effectively, by that 500 foot and being in business general, that effectively limits it to in the North Village, to the basically the end of Powder House or potentially on Kendall. Our bylaw differs from the state in that it limits the size of the facility types. The different types of, there's 3 different types of facilities. They're all indoor. It does specify the outdoor parking and signage and things like that. The state law does that. And it can't be in any building where where there are medical offices or anyone who could prescribe it. We had, in our article, as you can see, we left the permitting authority open, and what I suggest is, let's see, I'll just point that out, is 4.7.6.1, where we said, we left that open. We suggest making that the planning board until we specify otherwise. There's another board, but that's offered to be the permitting board, but we, the planning board, haven't deliberated on that to sort of confirm that. So for now, I just consider this, the planning board is a special permitting authority, just to keep it simple, instead of leaving it open as a question. The site plan review is the planning board, so that's not a change. The role of the permitting authority, this is different than like a liquor license, which is an annual renewal by the Board of Selectmen, where this is different because by the state law, this is has a medical application, so the applicant, if they were permitted, has a term limit that's just based on how long they operate, that applicant operates it in ownership as a registered marijuana dispensary. So there's not a term limit other than unless they decide to not operate it as that or ownership changes, then it would trigger the end of that permit. So it's different than, say, a liquor license. This is only open to the caregivers or the prescribed patients. So that's what this warrant article is doing. It's giving the town the ability to specify the location, and if we don't do this, then it could be placed anywhere in town.
Comments from the audience on this?
I got a couple of comments. First, many towns are doing this. This is a prudent step to take because if we don't do this, we are wide open. Second comment would be that I did have a conversation with the person in charge of awarding these facilities. She works in the same department in the state that I do. And no one has targeted Sherborn as a potential site, has ever mentioned Sherborn, and it's not on their radar screen that something is imminent. But it could happen in the future. These licenses are here forever. So it ought to be addressed.
Once we start promoting agriculture.
Yes, under the right to farm bylaw. The next comment would be that I had urged that the planning board be the special permit granting authority because most of my towns are going with the planning board. It's a logical extension for the work that they are already doing with site plan review and other special permits. It just seems to make sense. Plus, they're the ones that have done all the work in putting together the bylaw. They're familiar with the bylaw. There's a certain logic to having the planning board do that, so I'm kind of urging you to actually take it on. I know you're tentatively doing that, but I'm urging you to do that permanently. And I have one suggestion for an amendment, and that is that the moratorium that we adopted expires on June 30th. So one thing that we've been doing in other towns is to have a line here that extends the moratorium until the Attorney General approves the bylaw. So that right now, even though there's nobody on the wings, our moratorium expires on June 30th. If town meeting adopts this, it has to go to the Attorney General to be approved. That's a lengthy process. We wouldn't hear, in the best of cases, until August. So it just plays it safe that the moratorium continues until the Attorney General rules on the bylaw. It's like a one-liner at the end of the text.
Okay, thank you, Paul. Any other comments in the audience? Okay, how about up here? Oh, Elliot?
Here we go again. Where you can locate this thing is probably under my bedroom window, like everything else you've located in town that's obnoxious to me. I think 5 Powder House Lane would be 500 feet from the Sherborn Playground, and Fitzpatrick's property, which is zone business. And so here we go again.
Thank you, Elliot.
So I'm opposed to the whole thing.
Any comment up here? Okay, I would ask, people are comfortable if we make a motion to include Paul's suggestion of extending the thing. Okay, so then I will take a motion to recommend favorable action on Article 25 as amended to extend the moratorium until the Attorney General rules on it.
And aren't you also identifying the planning board as the special permit granting body?
Oh, okay.
That's in there.
Is that not in there?
No, it's
as an alternative with a couple of others.
Oh,
Okay, well then, yes, with the stipulation that the planning board also be.
subject to
be
your...
the-
so
Okay,
moved.
so move, second,
Second.
all in favor?
Discussion?
Oh, sorry, discussion, yes.
If we word it that it's only until the Attorney General's review, what if the Attorney General has some problems with it? Should we make it even more broad on that extension?
Rules.
So she rules, but she will not grant any longer. The reality is, she's willing to allow these extensions, because we consulted with her on that, but she has already taken a position. I asked in another town, for the town of Canton, where I'm town council, I asked them for an extension to January 30, 2015. She struck that and left it at June 30, 2014, would allow only 1 year, and said that was enough for a town to undertake. You can't have an open-ended moratorium on these things. That's it, we've used our time.
I was just going to comment, say, you have to make the extension until the Attorney General rules, up or down, or she could approve it with, and take out parts. I mean, they do that sometimes, but you want to, just till she rules.
All right, so we've made that motion. Has someone, I called for that motion. Someone made and seconded. Okay, all in favor? Okay. Article 26.
Article 26 is a suggestion to amend the basic zoning bylaw requirements 1.3, which are basic requirements to add lighting. What's in our existing list of kind of environmental parameters that might be perceived as injurious, obnoxious, offensive, dangerous, or a nuisance are noise, vibration, concussion, odors, fumes, electronic interference, debris, refuse gases, dust, harmful fluids, danger of fire, explosion, smoke, excessive drawdown of groundwater, or discharges to soil, air, groundwater. So we just don't have lighting in there. And what inspired this was a new type of barn construction that is transparent or translucent, so that lets daylight in during the day, saves energy, it's a good thing, but at night, when it's lit up, it glows like a giant nightlight. So the idea here was to allow lighting to be dealt with the same way these other environmental parameters are. We had talked about coming up with more specific lighting criteria, but we don't have that at this point. So the way our proposal is, we just add lighting to that list. The building inspector would be the enforcing officer.
Comment from the floor? Elliot?
This is something that I do not take lightly. There are right now, or after the sun goes down, about 9 lights from the Sherborn Inn that shine on my house, and I object. I've objected to these lights before there was a Sherborn Inn. When they started to propose it, I says, don't shine lights on my house. Oh, we won't, no, we're going to plant hemlock trees. You won't have any problems. Yeah, that was about 25, 30 years ago. The lights have shone I've been complaining for 25 or 30 years, and drive by after dark tonight, and you count them. There's about 9 lights that shine from just the Sherborn Inn. Ed Rose put up some lights behind his garage. They shine on my house and barn. At the zoning board meeting the other night, I said no permits for Rose's garage until he gets rid of his GD lights that shine on my house. And I got some pretty insulting statements, pretty stupid statements by people who have not stood in my backyard and had those lights shining on them. So I'm just amazed that this was not put in on the original objectionable noise and dust and vibration, that lights were not included. I just can't imagine that we have to do this now. But also it says here, to the community, and I think you ought to say, or individuals, or individual, singular, because I've been told I'm the only one that complains. Yeah, well, I'm the only one that lives there, so nobody else gives a damn. They all live 3 miles away. What do they care? I'm just an old grouch, and I'm just trying to make trouble for people. And I'm just trying to live in my house without all these damn lights shining. I'm not asking it to shut them off. I'm just saying put a pipe plate in front of them so they don't glare across.
Okay,
Put your lights down on your yard where you need them, but not over onto my house.
Thank you, Elliot.
Thank you.
Any other?
Susan Tyler. Though I do have an identical twin, so I might be Sarah, if it makes you feel better.
Is that the evil twin?
You'll trade me some Odessa lights.
Well, there was a question whether we were switched after a week.
Let's go.
Anyways, my comments on the lighting, first off, you mentioned this has come up because of some agricultural buildings that have been put up. And again, I would, as a member of the Agricultural Commission, I would say you have to be careful as to the regulations that you're putting on agricultural uses, because you may be needing the lights on. If it's a boarding facility for equines, they have the right to be out there. And, but my biggest concern about this is, how are you going to measure it? How are you going to measure it? I mean, we all know that you can drive down some streets at night and the driveway's lit up like a landing strip. They got spotlights, you know, shining up on the houses, up on the trees. How are you going to... It's the regulating part of this.
Anyone objects?
Thank you,
Thank you.
Susie. Any other?
From the Board of Selectmen, I'll speak for myself. We didn't take a vote on this because we had varying positions, but I did raise that concern, similar to Susan's concern, that it's very difficult to enforce a provision like this. I know from years on the Zoning Board of Appeals that even the other nuisance provisions dealing with dust and other items, they become fodder for litigation or for arguments at a hearing, because different people have very different tolerances for things. True Walter or whoever is the zoning enforcement officer at the time would be the person who made that judgment, but I do think it does expose us as a community a little bit if we don't have some better performance standards specific to this issue. On the other hand, I don't disagree that it's a gap in our regulation. We have some lighting regulations, but we don't have ones that are universally applicable like this would be.
Paul?
As Michael said, we didn't take a vote on this, but if I could shed some light on this, I'm in favor of regulating lights. I think most of my towns have some provision regulating lights. We should have a provision regulating lights. But I can't disagree, much as I want to, with Michael's point that there needs to be a measurement. Just like with sound now, I recommend to my communities they have a decibel level at property lines to measure it. What's missing here is a lumen count or something at the property line or some other location, a objective standard so that the property owner knows what is allowed and what isn't. Similarly, the abutter, if you had somebody like Mr. Taylor who says he's getting too much light, it's all a matter of arithmetic. It's not a matter of his word or someone else's word. It's just there. So we want to see the light covered. It would be wonderful if you could add 2 or 3 words to this that would provide a clear standard.
Thank you, Paul. Is this new information, Elliot?
So I want to add to this, trying to put intensity down. Before they opened the Sherborn Inn, they mentioned noise. They said, oh, we'll put up decibel meters. And I says, I don't need decibel meters to tell me that this noise is obnoxious. And the same with lights. I don't need lumens meters to tell me whether I object to light shining in my face or on my property. So it's just up to each individual to complain and have some action taken. I feel that I'm being bullied by these damn lights shining on my house. And if you read the newspapers and watch the TV, you better be careful bullying people, including me.
Thank you, Elliot. All right. If there's no further comment from the audience, I'll bring the discussion up here.
I would mention it's not just the light intensity measured by a lumen count, but I think in one specific case that motivated this, it's just the sheer size of something that could actually be putting out very low level of light, but the sheer size of the building made it
Right.
weird.
May I comment?
Yeah, sure.
That's the problem. This isn't easy to define, so we looked at some different methods of defining light in different ways, but we haven't come up with something yet that we think would make it easier to enforce.
It's the glaring of the lights.
Yeah, I have a comment and a question. I don't think there's any other parameters for these other things that are a nuisance, right? So it's kind of, light's just the only one. It would maybe be helpful, but it would be out of place.
Well, I mean, Russ, if I can comment on that, I think exactly the opposite. I think that would, defining light a little bit better would actually give us more protection on light. I mean, we may want to, over the longer term, think about standards for some of the others as well, at least ones that are conducive to measurement. And the other point is, it doesn't necessarily have to only be a lumen standard. Other municipalities have downward-facing lights, the fact that they can't shine it all off the property. There are lots of different ways to do standards like that.
And thank you. And how does this sort of go down? Like, let's say somebody like Elliot Taylor is objecting to the light. How does he get that enforced by your board, or you just do it sua sponte, if you know?
As with these other parameters, it's really the zoning enforcement officer, in this case our building inspector.
He complains to the the building inspector, who then brings it to the board? Is that how it works, or?
No, the building inspector is the zoning enforcement officer. So it would be entirely in his hands, and then it could be appealed to the ZBA, but the planning board is not an enforcing body.
Christine Coney, 55 Maple Street. I just feel that you should act in favor of this if there are not measurements for the other things like noise, and you have noise and dust, and there's not measurements. I think at least at this point that it should be approved. And I think Elliot is not just an old grouch. Maybe he's an old grouch, but he's not just an old grouch. And I think he's been complaining about I think he's been complaining about this for years, and I think that, he has the same rights as anybody else, and then maybe, it could apply to a lot of other people as things expand over time, but I think it should be included if the other ones are included, and if there are problems with it, then in the future, the same way that there aren't measurements for dust and noise, that those, should be taken up at that time, but I think right now it should be approved.
Eric, you have a comment? You have a comment?
Eric Johnson, Sherborn Planning Board. In the Sherborn Planning Board discussion, there actually was some discussion about setting an objective level to this. And there was some concerns that there's already subjective natures to it, not just to what exists, but we use sound as an example. Whereas there are issues of monitoring sound in certain towns because not all sound is the same. For example, 70 decibels at one frequency is far worse than 70 decibels at another frequency, or sudden sounds and things like that. And there are often issues in trying to measure that or quantify that. So it's left to a subjective nature. And we thought light was the same way. The barn might just be a glowing thing, but it's 150 feet long and 20 feet tall, has a different effect than a single spotlight. Different colors and so on like that, just like the frequencies of sound. So we thought that leaving it subjective as it exists. And right now with some of these existing, what's in the law, these other aspects, we didn't know of an example where someone came down to, well, I disagree and there's issues with kind of regulating that. There was one other point I did want to make, because I think it goes to the comment just made, at least in Ellie's situation, that this is a zoning bylaw, not a general bylaw, so there will be grandfathering provisions. So essentially if there's a pre-existing condition, or if there's, this will only regulate a new condition or a change of condition.
Any comment up here?
Just one more.
Sure.
I think of the choices between no regulation of lighting and regulation of lighting, we would, at least I would go with the regulation of lighting, even without standards. So I agree with the statements. Lighting needs to be included on this list. The idea of having standards is a wish list because we don't want to spend money on lawyers if we can avoid it. But some regulation is better than none.
And we all agree with that.
All right, then. There's no further discussion. I will take a motion to recommend favorable action on Article 26.
Motion?
So moved.
Second? Second. All in favor? Article 27.
Article 27 is about floodplain mapping. And in 2010, we updated the Middlesex County digitized maps, and now the Sudbury Basin watershed, there's a new study out that they sent us new maps, and so it's time to update them again. In this case, it's because there's new information, there's new data, it's not just a digitized map, it's new data. So this article amends our existing bylaw, and it's a situation where if we don't amend our zoning bylaw, then those residents that are affected won't be eligible for federal insurance. If we do amend the bylaw with these maps, we're just changing the names of the maps, then if we do amend it, then those that are affected would be eligible for federal insurance. There's some additional language that's just putting us consistent with the new state language. The areas that are affected are in maps. I've got a PowerPoint I could show you, but it's a little difficult to read the maps. I don't think they project well. But the only areas, there are very small areas that are affected in town. The only areas that are populated with homes are the areas that have already been in the previously defined floodplain areas. The areas that are changed, it appears to be basically Meadowbrook. That seems to have some change, but we will notify those that are in the areas of the Sudbury Basin watershed mapping areas. Again, this is a case of if we don't do this, then folks won't be eligible for federal insurance, and if we do, they will be eligible. It's got nothing to do with rates or anything else.
Any comment?
The selectmen supported this article.
Any comment up here, questions? Okay, then I will take a motion to recommend favorable action on Article 27.
So moved.
Second? All in favor?
Thank you very much.
Okay, Article 28, I am going to put a hold on Article 28. This is to see if the town will vote to transfer from free cash and what sum we would vote to transfer. And I don't want to address that today because among us, we need to discuss a little bit more about funding some capital articles from our guidance reserve and free cash, and I think it's late enough that we don't want to get into that today. Article, so that will move to the end of the hearing. Article 30, to see if the town will vote to raise and appropriate or transfer from 29, I'm sorry, to see if the town will vote to raise and appropriate or transfer from available funds a sum of money, and if so, what sum, for the purpose of increasing the stabilization fund, or take any other action related thereto.
I can speak for this. I solicited from the town treasurer some opinions about what would be prudent there. If I may sort of paraphrase, he said, well, there's a couple of, on one hand, you could have an amount like 50 to 100,000. You would do that just to sort of keep pace with inflation and the growth of the town's financial responsibilities. It would keep us definitely above our reserves policy specification. But he also said that maybe 30 to 50,000 would work. So when it comes time, I would make a motion to transfer 50,000.
Okay. Is there,
we can have discussion.
yeah, is there comment from the audience on this first of all?
I'm glad to hear that you're suggesting putting something into the stabilization fund. Nothing's been done to that for a few years while focusing on the OPEB stabilization fund. So I think it's prudent you do something, whether it's 50 or 100, it depends on where you fall out on free cash availability.
Okay, any comment up here? Okay, then I would make a motion to recommend favorable action on Article 29 and to the sum of $50,000.
I so move.
Second.
Any further discussion? All in favor? Okay. Article 30, to see if the town will vote to raise and appropriate or transfer from available funds a sum of money, and if so, what sum, to be deposited into the town's other post-employment benefits stabilization fund, or take any other action related thereto.
I can speak for this. Because of the next article, we're taking an approach of putting the funding into an OPEB, as it is other post-employment benefits trust. And the trust is a different legal structure than the stabilization fund. Once the funds are put in there, they can only be used for retirement insurance benefits. We'll talk about why we would do that then, but my recommendation when it's time would be that we either vote no action or vote $0.
Is there comment from the audience on this? And is there comment up here?
Well, I guess I'm wondering, how we're handling the transfer, because we're actually taking money out of the...
That's the next article.
Okay.
The next article, handled through that.
Then I move no action.
Okay, so I would take a motion to move no action on, to recommend no action on Article 30. Okay. Second. Second. All in favor?
Can I ask a question? So is that because you're talking about just bypassing the stabilization fund, putting it directly
Into the, yes.
All right, so it's covered next time.
Okay, so all in favor? Okay. Article 31, to see if the town will vote to raise and appropriate or transfer from available funds a sum of money, and if so, what sum, for the purpose of funding the other post-employment benefits liability trust fund, or take any other action related thereto.
I can speak for this. As I mentioned, there are different legal ramifications to whether the money that we set aside for OPEBs goes into a stabilization fund or into the trust fund. And as I said, we've taken a decision to start utilizing the trust fund. It will have some benefits in terms of our audits and how these liabilities are calculated. So this is definitely progress in the long road to fulfilling our OPEB obligations. I think in our last meeting we had kicked around several ideas, and our inclination was that we would transfer from the existing OPEB stabilization fund $200,000 to move into the trust, and when combined with the $100,000 which is in the operating budget for OPEBs, that would be an initial contribution of $300,000 into the trust. Since there's a minimum of $250,000 for an initial installment, we'd be well beyond that. The main other benefits to investing in the trust is that this would be managed by the, I forget their name, but it's the organization that manages the state pension funds. PRIT. And they seem to have been doing a very good job. A really good benefit of that is that it will be invested for the long term. As long as it's in stabilization, it's been invested in very safe, very conservative, short-term investments, earning basically nothing in the current environment. So I think we had even considered suggesting moving everything into the trust, but the trust does have some risk of variance due to markets. Over the long term, that should not be a problem, but I think we were just inclined to be a little bit cautious at this point and make a partial funding of the trust fund.
One clarification too, and then the result of that would be there would be 300,000 in the stabilization fund still. We would have 300,000.
I believe that's correct, yes.
Right.
Yeah.
We'll probably do something like this again next year.
Setting aside 100 and transferring another 200 to the
Correct.
state.
We've allocated through the operating budget 100, and this will require a transfer, and that will require a 2/3 vote at town meeting. Frank?
Frank has South Main Street. What do we have presently in the two stabilization funds, the regular stabilization fund and the OPEB?
It's slightly more than 500,000 in general and slightly more than 500,000 in the OPEB stabilization. The treasurer can correct me if I've got that wrong.
Okay, so if in a future year we had a very tight year and we needed some funds, could we use some of the funds in this new trust fund that you're putting these in to pay for retirement things for that current year? We could use it to pay the pay-as-you-go for that year if we were very tight?
We could, yes.
Okay.
Not from the trust fund.
Yes, the trust fund is for paying
For that purpose only.
retiree health care benefits, so it doesn't have to be in 30 years. We could make a withdrawal for that purpose next year. We hope that
But
doesn't
only for
happen.
that purpose.
Right.
That's right.
Yeah, so Mary, I'm delighted that you're taking this next step on behalf of the town to put some money into this OPEB trust fund, and I appreciate the sound thinking that you're using for the amount that you're transferring as well as retaining in the OPEB stabilization fund. So I just want to say that's great.
Any other comment? All right, so I will take a motion for favorable action on Article 31 to recommend transferring $200,000 from OPEB stabilization to OPEB trust. Second?
Second.
All in favor? Okay.
Do you need a motion on the 100?
We put the 100 in the operating budget.
No, we didn't. Let's
Oh,
hear from the
oh, I
treasurer.
see.
My only
Right.
question on that 100,000, does it specify that it goes into the trust? Does the
Okay.
general budget specify it goes into the trust or into the OPEB stabilization?
We
I
have
think the accountant has it labeled simply as OPEB. Is that correct? Okay.
Okay, and so it will be voted that way at town meeting. Do we have to do that in advance of town meeting? Does anybody know? We don't? At town meeting, it'll be specified that money that we're appropriating, the $100,000 in the omnibus budget, will go into the OPEB trust. I just want to be sure we don't have to do that beforehand.
As Ruth said, it would be footnoted in the general appropriation budget.
Okay.
That should be in your report to the voters.
Yes, definitely. Okay, it is 5:05. I would like to call a halt at 5:30 on this meeting today, regardless of where we are, but I would like to begin to address Article 32. To see if the town will vote to rezone the land located at 90 Maple Street.
Mary, sorry to be a pain. Just briefly, did you want to do the farm pond thing? Because we did wait for someone to be here. She's been here this
Well,
afternoon.
we did say we would put it at the end, and there are other articles
call.
also held to the end. I'm sorry, Kath, So to see if the town will vote to rezone the land located at 90 Maple Street from Residence B zone to Residence EA district, and to grant preliminary development plan approval pursuant to Section 5.6.3 of the zoning bylaw, so as to permit the development of over 55 housing on said land as detailed in the preliminary development plan presented at town meeting, or any amendment approved at town meeting, or take any other action related thereto. And I believe, so is there a citizen in the town who would like to make a statement as a proponent of that article? Sheila.
I'm Sheila Bresnahan at 6 Russet Hill Road. I'm also the chairman of the Council on Aging. And a few years back, the Council on Aging decided that, as a board, that we wanted to pursue an over 55 development in town. But we felt before we did that, we should really find out what the townspeople felt. So we passed out a survey at the November 2012 election, which came back, 512 were returned. Of those, 362 came back saying they were in favor of a development. The price points were from $450 to over $1 million, of which most of them were between the $450 to $750 range that they would be interested in. So the board voted that this would be a priority for us to find and try to pursue an over 55 development in town. When we found out that Pulte was thinking of doing a development on Maple Street, we invited them to our meeting. They gave us a presentation. At the end of the presentation, we all met, decided there were a few concerns that we had, one being the price point. Theirs was a little bit higher than what came back from our survey. The area that they were building in, there was a lot of trails and stuff. Some of those trails would be gone. They had a actual drawing of, like a layout of the plan, which had some of the backyards were facing into each other. We went back to them, made recommendations, said, maybe you can do some duplexes that are at a lower level. And they ended up coming back. They changed their entire plan. None of the residents right now face into another one's backyard. They kept all the trails and added new trails and have made them all so that they all connect now. They, what else? They did the development. Anyway, they came back with all of our demands and really redesigned the entire plan. They have gone above and beyond what we have asked them to do, and then we heard concerns from other people in the town saying they didn't like the Pulte design. So we did, as a group, went out and looked at some of their developments in Acton and in Bedford. We were all enthusiastic with their designs, the layouts, the construction. We came back, had a special meeting, and voted unanimously that we wanted to support the over 55 development. We feel it is in a location which for the town is great. It's not going to interfere with the majority of the residents in that area. It is set back off of Maple Street. There's lots of forestry kept. The trails are all kept. The designs are nice. The community is got more than a quarter of our community, our town, is over 55. And a lot of them want to stay in town, but they don't want to stay in their own homes. They want to get into smaller homes, and we feel that this is a great solution for the town. And so our board has voted unanimously to support this project, and we hope that you all do as well.
Okay. I'm going to open the conversation out to comments from the floor, and if you wish to speak, please.
No, he's got to present.
Oh, well, yes, you have a few more minutes, I guess, on the, right, on the 5 minutes, sorry.
presentation, can you do the presentation?
That was just, the presentation has been made multiple times, and every proponent gets 5 minutes. Mark understands that.
Yes, I understand.
Yeah. Okay, so you get the rest of her 5 minutes.
Yeah, that's fine. So, for the record, my name is Mark Mastriani. I'm here representing Pulte Homes of New England. We're a residential for-sale home builder, and we have under agreement to purchase the Gray Family Estates or Farm at 90 Maple Street. And the reason the warrant article is here on your warrant, the article is to for the town to vote to support the rezoning of the land from Residence B, which allows us only single-family residential development, to Residence EA zoning district. It's an existing zoning district in your zoning bylaws, which allows a proposed senior housing development. So that's the warrant article before the town, for the town to support. This location to be used for a senior housing development. It's a well-documented, known issue that there's a need in town for senior housing. There's a need in town for an alternative type of housing for seniors to downsize, stay active in the community, stay local, remain with their families, and to remain in the town that they grew up in. And there's very limited supply of housing available. So Pulte Homes has proposed a senior housing development for the town, and as part of the rezoning, the planning board regulations do require a preliminary development plan. So we have given the presentation, the full presentation, many times, and I know I'm running out of time here. So what we did is put together a quick little packet for your board and for the selectmen, and essentially it hits the highlights. It's a 66-unit senior housing development on 88 acres of land. Its primary access would be off of Maple Street. It's a mix of detached and attached homes. Each home will have 2 bedrooms.
I'll give you another 30 seconds
Yeah.
since I took some of your time.
Yeah, especially designed for seniors. Of importance, more than 60% of the land will be retained as open space, which is far exceeds zoning requirements. Of significant importance, the existing trails on site will remain open to the public for the public to continue to enjoy, and also wherever the development impacts them, we've committed to creating continuous connections. Also of significance, our fiscal studies show that this community, as proposed, would bring $762,000 a year, sustainable annually, net revenue to the town. So it's a fiscally beneficial project. And one of the things I want to commit to tonight is we've been going before the planning board many times, and there's been some discussion on the fiscal impact of the project. And my company is prepared to further restrict the age-restricted requirement. Right now, the zoning only requires one person to be age 55 years of age or older. And in either our master deed or our condo bylaws, or if subsequent planning board special permitting process, we're okay with committing that no permanent residents under the age of 18 would be allowed to live in the community. So that should put an end to the school kid discussion that's been continuing. And on the last page here, it talks about the benefits to the town for approving the rezoning, and one is significant and sustainable annual fiscal benefit. Second is alternative quality housing for seniors. Third is preservation of considerable contiguous open space areas. And many of these open space areas abut existing town open space areas too, so that's a benefit. And the last is the continued use of a vast network of on-site hiking and pedestrian trails.
Thank you very much. And thank you, Sheila, as well. Okay. So now I will open it up to the floor, and the first person in line is the first person to speak, and 2 minutes.
My name is George Morgan. I live at 41 Bear Hill Road in Sherborn. And I submit this proposal is given to the town by Pulte does not meet the basic requirement or the intent of EA zoning. There are at least 2 criteria, and it seems to be only 2 criteria, that Pulte has been asked to meet on this score. One is the 1 mile distance from the center of town in which EA zoning is thought to be advantageous to seniors. This project, or maybe just a part of it, is on the perimeter of this 1 mile limit. Now, how convenient is it for seniors to be walking a mile uphill on a street with no sidewalks? I submit that is not a convenient location and not inconsistent with the intent of the EA zoning. The second is the 55-year-old discrimination bit here. Usually this is where you start with a proposal, not where you end with a proposal, which is what has happened here. If you look at retirement communities, nursing homes, assisted livings, they do not stop at just a 55-year and over requirement. They offer amenities such as recreation, such as social services, such as medical oversight, such as gated community security, such as security personnel on site, such as common areas for meeting and dining, such as transportation, such as concierge services, absolutely none of which are present in this proposal, none of which in this proposal recognizes that seniors age in place, and that when and if they have to leave, they are going to be stuck with either getting their money back on this project or having to still continue to pay condo fees, taxes, and mortgage on a location they cannot no longer live in. And which money is money they're going to need for wherever it is they have to go in order to have their needs actually met. This is a predatory program on seniors. It is not a benefit to seniors. And on these 2 points, location and the age requirement, these are not elements that are going to be attractive to seniors. This project falls way short of what seniors need.
Okay.
Thank you.
Thank you.
Ted Long, 129 Maple Street. A couple of questions for Sheila. What was the vote number on the survey you had?
Oh, there was 512 surveys were returned and 362 were in favor.
Okay, and this was done when?
This was done in November of 2012.
And how many members are on your committee?
Approximately 15 between associate members and board members. And they were all at the meeting
Do you have a
and voted
list
unanimously.
of? Do you have a list of them and
Microphones.
where they? Do you have a list of the people and where they live?
Of the seniors that are on our board,
Yes, please.
I don't have it with me, but they're all over town, and half of them are here, the
Okay.
board members.
Great. You can provide it to us
I can
later.
provide it, yes.
Okay. The other thing, I've listened to quite a few of the Pulte presentations, and the average price appears to be unaffordable for the typical senior, at least in my experience. It's higher than the Massachusetts definition of moderate income. I believe the size of the project, I'm not against affordable housing and senior development, but I believe the size of the development on Maple Street really will cause problems to the neighbors, traffic, and also will devalue all the people that live in that vicinity. And there's other issues that Mark has addressed, but we still think bringing the access road in there will be difficult. There's wetlands in that area. I think that we're going to damage that with the development. I do have some engineering background. Location on Maple Street is difficult, very short frontage for the access road. And I believe the market for 66 homes is going to be difficult for this project to sell, even within the 3 to 5 years that they project.
2 minutes. Thank you. Warren?
Yes, Warren Wheelwright, Hunting Lane. One of the key arguments I hear from people for this, even though they don't like the project, is they fear it will become a 40B. Well, that fear is quite realistic, and it is unfortunate and false security that if you give them an EA, they won't go 40B. They have the option at any time to invoke a 40B project. Pulte is an experienced 40B developer. They did it in Natick. They know what they're doing. It turns out that many in Sherborn aren't aware that a 40B is possible on an EA zone. And I'm getting somebody there looking at me quizzically. Ask a town council, ask one of the selectmen sitting on your left, you will find out. Now, this project will fail as an over 55, and that's when they'll invoke it. Dover had an over 55 just recently. It failed to sell. The developer went to Dover and they cut a deal, but it's under 55, it's a full project, bringing in children. So those who are thinking they're going to save money are going to, in fact, by inviting in Pulte, cause our taxes to go up. Why is it going to fail? Not only Dover's a good example because their development was in the downtown center, walking distance to the market and so forth. This is 1.5 miles, effectively, where you're not going to have a sidewalk. I worked for years on Maple Street to get a sidewalk there. You can't do it. Several people have tried. Massachusetts, as of 2013, had a 5-year inventory of over 55. You're not going to get people coming in from outside to go to this kind of location.
2 minutes. Thank you, Warren. Rick?
Hi, Rick Antel, McGregor Drive. I've had the good fortune to be able to walk these woods for the past 23 years, and I know good things can come to an end, but my question is, does it really have to end this way? Is this really the way we want to do it? And I would point to one aspect. In order to place these condos, the first thing that the Pulte plan identifies is they're going to create a plateau, a slice into that hillside that's roughly 650 yards long and about 125 yards wide. So that's about 18 acres of leveled land. On one side of that land, there'll be an embankment. On the uphill side, there'll be an embankment that'll run the entire length, and it'll be 10 to 20 feet high, graded at 2 to 1. On the downhill side, there'll be a similar embankment. So to my mind, this is a major change to the landscape. It'll require, according to the developer, it'll require big earth-moving equipment and blasting, and heaven knows how much noise that's going to make for us neighbors. Once that's completed, then Pulte can plant 2 rows of condominiums that entire length, and it'll create, to my mind, a very sterile facade, which is mostly just garage doors. I guess I have questions, which is this really sort of the beginning of the new design for Sherborn? I understand we need revenue, that makes sense. But does that require us to spoil our landscapes? Does it require us to dilute the rural character of this town? I believe there's a way to preserve our rural character and achieve the revenue we need. Thank you.
Thank you, Rick.
2055 Maple Street. I try not to be repetitive of what other people have said, but just to go over some of the points. The revenue stream, when Pulte first presented this to people, it was all about the revenue stream, how much it was going to solve our problems. Although I will say, they did say it wouldn't solve all our problems. They didn't go that far. They said it wouldn't, but they stuck to the $762,000 annually. That was based on, and their presentation, their backup for that was based on these units being started to be priced at $650,000, going up to $950,000 or more. That's where the revenue, well, Grace, I'm sorry. According to the COA presentation to the Board of Selectmen a few nights ago, Pulte's made these promises that they're going to have a lot of units at $450,000.
Nope. I said 550.
550? 550, okay. So we're shrinking the revenue stream. But more than that, I'm just wondering why the presentation changes as it's made to different boards. I mean, it's either 762 or now it's less than that if you're going to, because with same units, they're not reducing the units, and which I think is a problem. They never agreed to reduce the number of units, 66 units. They also have, after much urging from many people speaking at these meetings, have refused to put in any kind of a meeting room, even though that's a requirement of the EA zoning. It says, where feasible, and the only unfeasibility that they've come up with is that it's going to cost more money, or each unit would have to be a little more expensive. So they refused to do that. There are no amenities. As far as the distance from town, I have been told that it just comports with being not more than a mile from the split at 16 and 27. But the houses, having walked in there with the group from the planning board, and the feet, the houses at the end are a half a mile from the road, so that people living there are actually a mile and a half from the road. I mean, you could consider that a technicality, but it's part of the overall plan, I think. Thank you.
Thanks, Chris.
Paul Hardnett, 99 Maple Street. I'm going to read a statement. I did an objective informal poll where I called every Maple Street resident from Washington Street to Western on Sunday, March 16th from noon to 2 p.m. The results were 25 no's, as in no action, on Article 31, 0 yeses, and 5 undecided. I can absolutely say Maple Streeters do not approve of this zoning change in our neighborhood. Good people sometimes have bad ideas, and that can lead to bad projects. That's how I see Article 31. In general, the article subverts and undermines the intent of 2-acre zoning in Sherborn. Article 31 proposes an EA spot zone right in the middle of a contiguous 2-acre zone which makes up over 1/3 of Sherborn. Article 31 would set a pernicious precedent for neighborhoods such as Green Lane, Hunting Lane, Farm Road, Maple Street, Lake Street, Washington Street, and others. Specifically, Article 31 does not meet the legal requirements of Section 5.6.1 of the EA zone bylaw. Is 90 Maple Street, quote, appropriately located, unquote, so that it is, quote, readily accessible to shopping, transportation, and other public facilities and services used by the elderly? It is not. So Article 31 does not meet the requirements of the law. Is dynamiting the side of Bear Hill an example of utilization of natural features? It is not. Article 31 does not meet the requirements of the law. Is building senior housing in the middle of the woods on the side of a hill an example of, quote, provision of municipal services? It is not. It does not meet the requirements of the law. Is 90 Maple Street, quote, more than 1 mile by public way from the intersection of Main and Washington? Yes, the majority of the land is more than 1 mile and does not meet the requirements of the law. The meaning, intent, and spirit of the law is clear. Therefore, I ask the committee to vote no action on Article 31.
Thank you very much.
You're welcome.
Hi, Laura Hartnett, 99 Maple Street. I want to raise the issue of being very concerned about the potential decrease in home values near 90 Maple Street that this development may have. People move to Sherborn for good schools in the beautiful semi-rural environment. They don't want to live near a densely populated 66-unit development. I wanted to mention that my neighbor recently was close to a sale of her home, but the buyer backed out when they found out about the proposed Pulte development. So this is already occurring. I also have serious concerns about whether these 66 units in the projected $500,000 to $700,000 price range can actually sell at these high prices and generate the tax revenue proposed by Pulte. You can definitely buy a larger single-family home with more land in Sherborn in this price range. So why would you purchase a 2-bedroom unit in this development? I doubt that many people over 55 would be willing to pay the high prices and exorbitant taxes for these 2-bedroom Pulte units unless they're going to move in with children who will attend over Sherborn schools. If these units become filled with children of school age, there will be very little tax revenue for the town. Thank you.
Okay, I'm going to have, there's 2 minutes left until 5:30, so I'll take one more comment.
Real quick, this is my last comment of the day. Isn't that good? I support the article. That's it.
Okay.
We want just 2 more people?
No, this is it. I said one more, we will continue the hearing on Monday evening. And we will be Monday night, 7 o'clock.
Why don't we continue it then?
because
That's-
I don't want to just take 2 minutes. I may want to take a little more.
No, 2 minutes. You only get 2 minutes.
You don't have to use your 2 minutes.
That's right. All comments are 2
All right,
minutes.
Peter Black, Maple Street. This started with the Revenue Committee approaching Poultry, seeking their creation of this project, and it was sold as a revenue stream for the town. First of all, I think the town should be embarrassed and ashamed of trying to saddle people over 55 with taxes without getting the services that make this town so attractive. I moved here because it was a town with a lot of open space and great school systems. If we bring in 120, 150 people that aren't getting the value that we're all paying for in our taxes, are they going to go and vote to support better schools? Are they going to go and vote to maintain the open space? This is going to be, no offense, this is going to be a senior ghetto. This does not meet any criteria of Sherborn. People, if they burp, are going to have to turn to their neighbor next door and say, "Excuse me." This does not meet the character of Sherborn, and the idea that this is a revenue stream for the town, we should be ashamed of it.
Thank you, Peter. All right, so that is it for today, and we will reconvene on Monday at 7 p.m. Look forward to seeing all of you. Thank you, everyone.
Just summarize for everybody what Monday night's agenda is going to include.
Monday night's,
Article 31,
it will, Farm Pond, it will be free cash. It'll include this, free cash article, Farm Pond, and I had one other written down.
Article 8, Section 6.
28 and 29.
11, personnel contract.
Oh, Beto.
I believe it.